tomorrow lunch motion, medical admission, covered by lordships on 4 matters.
And the request on the intra-court appeal, that single judge on Friday has granted stay of elections of a multi-state cooperative society which are scheduled to take place tomorrow. 5 states correct society are operating. The petitions printed the ex parte interim order, correct? And tomorrow, all the elements are there, polling is to take place.
We can take it up tomorrow also.
Tomorrow is the election.
Election.
Tomorrow is the poll.
We'll see.
And the order was granted on Friday.
All right.
My lord,
My lordship, motion will not.
item 17, may I trouble this court if I can be given the indulgence and the matter be heard in the pre-lunch session? The difficulty that I find myself is that on Friday, 6th, in a part heard matter, the Honorable Supreme Court has kept it for 2 p.m. today. So I have to join online. In fact, it was a bench of Honorable Justice Nagaratna and Justice Bhuiya. Justice Bhuiya has extensively heard this matter and he's aware. So I told him, so they said, you go to Hyderabad and join from there online at 2 p.m. So if I can be given that indulgence, I would be very grateful.
No, see, madam, this case has to be heard finally, right? And what nothing else, right? What is left?
Please, my lord.
And what we have found is that the pleadings are still not complete.
My lord,
6-2.
I'm sorry.
Private respondents have not even filed the counter. And if we proceed to hear, it will be difficult for you to defend the order if it is passed in your favor in Supreme Court. They will say that without giving us an opportunity. Yes, who appears? Please wait, it will be called. Please wait.
I'm grateful.
Please wait. So that there we can at least put them to, yes.
Lordships, with great respect to this honorable court, IA number 2 of 23, in appeal number 222 of 23, expeditious
for?
petition, my lord. Kindly have it any date, my lord. Expeditious petition according to directions of
What is for?
issue there, my lord, senior citizen who is not granted the pension under learned single judge. There was substantial evidence, but erroneous in the allowed the repetition, my lord. This honorable court was.
So this is what final hearing.
Yes, my lord. I have filed IA also, my lord.
We'll consider, Mr. next month, sometime next month, not now. Second November.
My lord, the honorable submission, my lord, petition number 18510 of 2021, my lord. This is an illegal termination, my lord, without even conducting the inquiry.
No. See, you people want final hearing or what? I mean, they should tell. What is the urgency?
Urgency is termination. my lord.
Termination. Every case, what is not urgent in a matter which is pending before 2005? Since 2005, you tell us.
My lord, sir, respectfully submit that an early hearing may be at least.
Next month. Sometime date in the next month, not this thing. 6th November.
Please, my lord.
No, not for final hearing. Your application
Yes, my
for
lord. I understand.
fixing a date is
My
not.
lord,
We don't fix final hearing by these mentioned members. Yes.
please.
I am in a disposal of matter seeking a direction. In this matter, while granting interim order, this honorable directed to deposit the amount in the register, and the same amount has to be placed in FDR. That was direction. After disposing of when we asked for refund of amount, the registry said, you are not entitled for interest, and we can.
There is an application seeking withdrawal of the amount.
Yes.
All right, 12/10.
Tomorrow.
A day after. Yes.
Enforcement Directorate has seized the bank accounts, my lord. Filed an application, petition for refreezing of the accounts. Readings are completed, the entire regarding pertaining to seizure is also placed with the lordship, my lord. The request hearing, my lord.
Final hearing.
I ask for a fine.
We will take up your IA next month sometime.
One more request.
6/11.
One more request.
For application for fixing a date for early hearing, not a date.
One more request. The community hall has been done into a dumping yard. I have filed a petition bill, my lord. Applicant has indicated.
Final hearing. All. Fresh matter. No, you must tell us for what purpose first you want listing. Final hearing. We don't have time right now. It will come up next month sometime. Yes.
My lordship, lunch motion, my lordship.
Why?
Medical admission, my lordship, covered matter. Two motions.
Can you make a request regarding posting of the developer to the application? I have made infield application as well as state.
All right.
That what is the run
Ah,
directly to the staff for 3 weeks. Not listening.
all right. 1710.
Your Lordship, if I
And your
may,
eye is right. Yes. ma'am.
Lordship, if I may, Your Lordships had had a chance to listen to this matter, Your Lordships. It's a Gazette Register matter in which the dispossession has happened and they have not paid the compensation yet. The pleadings are completed, Your Lordships, and Your Lordships has also heard it.
You know, madam, you argue that such lengths that we gave up, right? That this thing, right? That 11-1, that notification, right?
Lordships.
You argue that such length and we gave so much of time that we gave up. It's not possible to
Your-
decide.
Your Lordships.
If you want the matter to be heard, you have to be reasonable. Prepare a synopsis, conclude within 10-15 minutes, understandable.
Yes, Your
But
Lordship.
you will argue for hours together, and how many times we have heard your case, you tell us.
That is
So
going
if
to
it's final hearing, then we will consider next month, not.
We filed
not
the
this.
expedite also, Your Lordship. We filed-
Expedite petition will come up sometime in the next month, 8th November.
Oblige, Your-
Expedite petition, we
Yes.
will fix the date thereafter.
And I filed the synopsis also, Your Lordships, long time back. The
We have heard it, all order sheets, facts have been recorded, you have to conclude, you are just arguing like this.
Will only take,
Leisurely, this can't be done.
will only take 10 minutes to
Oh,
conclude, Your
no,
Lordships.
2005 matters, there is no absolutely, there is no justification why we should not first hear 2005 matter and give you precedence over others.
Just that
Absolutely
the
no.
situation is urgent, Your
Let's see.
Lordships. Yes, Your Lordships. I'm deeply obliged. 811, Your Lordships.
Yes. And your application, madam, for fixing.
Yes, Your Lordship.
Not
I
final hearing.
will take my indulgence,
Yes,
Your
yes.
Lordships. I'm deeply obliged.
Yes.
May I please your lordship?
Your lordship.
Representing Muhammad Nasiruddin, my lord, this is the matter I filed. File the writ appeal.
Before my learned senior colleague start, I wanted to mention one thing. We are board is also preparing the appeal against the set order, your lordship. It will be heard together next week, your lordship. Tomorrow we are
The
filing.
only thing is that his right to offer prayer, how it can be taken away?
It is not, it is right to offer is different, my lord.
Ah,
Under section 64,
ah.
the right has been saved is that if he,
All right, so let him file an appeal
my lord,
also. We'll take it up next week.
my lord.
When will you file?
Tomorrow I am filing the,
Achha,
your lordship, any date.
Mr. So-and-so, learned counsel for the Telangana state.
Oblige.
Yes.
On behalf of petitioner for the law,
Ah,
for the condoned delay,
ah,
133 days.
yes. No, condoned delay. What is delay condoned? Argue on admission. Yes. You are seeking a declaration that the sale deed is void.
My lordship, my contention is basically,
Hmm.
my lordship, as per.
You are claiming on the basis of an agreement to sale in respect of which a suit for a specific performance is already pending. You seek the relief of this declaration of sale deed in that suit,
We are doing
right?
that.
Doing that,
But-
then there is no this thing.
But my lordship, the,
Correct.
I filed a writ petition challenging the action of second
We
responsibility
have read it. That's why we are asking. Yes,
in affecting the registration of non-agriculture land
all right.
by the MRO, which is empowered.
Yes.
My lordship, if you can see the definition of the land rights in land and Patara Passport Act, my lordship. Land means land which is used in our.
Who are you? Who are you?
I'm the petitioner.
Petitioner means what right you are claiming in the property? Who are you in the context of an order passed by learned single judge? Because learned single judge has held that you, what is your title?
Your Lordship, I have got an agreement of sale.
Then you know what sort of a right it is.
My Lordship, and when, my Lordship, during the final hearing, I will apprise this honorable.
No question of, it is being heard on admission first. Final hearing comes later. Yes. 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 Go ahead. Why?
Yeah, my Lordship, basically the delay was because I was suffering with
No, delays condoned. Argue on admission, mister. We have accepted you are suffering from fever and everything. Yes. So, argue on admission. Not ready, right? No, nothing.
post after the vacation.
Why? 2 days you had you had noticed that it is coming up. Today is Monday. Saturday, Sunday, you can't prepare the case. What were you doing? Nothing, mister. File a suit. This heard on the question heard on IA 1 of 2023 an application seeking condonation of delay for the reasons assigned.
Maybe.
Yes.
The philosophy the
Ah,
appeared for the loss of the NEET exam is actually
ah. So why you did not apply?
also because I'm pursuing the degree loss of the fourth respondent loss of the college. But they have not.
So what can be done?
What you mean, how your lordship, the last date is was 14/9.
So you are not
But many-
applying.
many-
What can be done?
Not, it is a many court order, it is not, the,
Eh?
I could not get the lordship in the.
No. Rules or the norms which have been laid down by an authority applies equally to everyone. Why you did not apply? What can be done? What is your legal right to seek admission
not saying that.
beyond 14/9 and register? What?
I'm pursuing the degree. in
You
PhD
pursue degree.
education also because I could not get also because the certificates also from the college. That's why
We
it's not
can't do
online.
this thing. You submit a representation to them. If university permits, that's fine. But we can't do anything. Right?
Lordship,
In this petition, mark the presence. Notice.
My Lord, humble submission. I am appearing on behalf of Mrs. AVS Lakshmi, my Lord. My Lord, this is a writ,
Yes.
this is a writ,
Satyavati Tandon.
my Lord.
Satyavati Tandon.
But this is a writ petition filed against the premature sale certificate issued by the DRT. my Lord.
It's a measure taken under 13(4).
Yes, my Lord. Now,
Order passed by DRT.
DRT,
12(6).
the issue involved is the installments were
Satyavati
regularly.
Tandon, what is your answer? That binds us three judge, this bench,
My Lord, this is
and
the,
it binds us under Article 141. Supreme Court has deprecated the practice of entertaining the writ petition.
my Lord.
And by now we thought that everybody in the bar knows that we don't entertain the petition.
No.
But despite that, it is being filed.
My Lord, this is only.
See, Mr. We may be wrong, but we would like to be consistently wrong.
Well,
Because our order has not been shown that it has been reversed or set aside by Supreme Court. So we are bound, this is the order. We cannot take a different view in your case for whatever reason.
with apologies, my Lord, it's only a small relief, my Lord. At least liberty may be granted
To file an appeal.
file an appeal before DRT.
Yes. That
In the appellate.
DRT appellate
Yeah,
trial.
appellate.
Yes. In this writ petition, the petitioner has assailed the validity. Instead of filing an application for restoration, you are coming here. That shows your client doesn't have money to pay it to the bank, but he is willing to spend it on litigation.
My lord, I
right?
have already
Fine.
paid almost 66%
Fine.
of the
We don't know. Yes.
obligation.
Third, on the question of admission. Petition is admitted for hearing. Notice. Yes.
Much obliged, my lord.
Yes. Password.
May I please? The last occasion, not your lordship, wanted to bring the citation. Not
What is the position?
only the latest, not the citation with regard to
Paragraph. So what is your submission?
submission is, I impleaded the 7 and 8 by name as attributed modifieds against them.
Respond number 7 and 8 by name because
I attributed modifieds against them,
where have you attributed?
not
Which paragraph? of the
para 39 onwards.
Para
39
39.
onwards.
Hmm. Hmm. Onwards till which paragraph?
Not up to 49, you know,
Till 49.
49. Categorically stated that I attributed modifieds and allegations. Therefore, it becomes,
We will go to, we are going through.
yes.
Yes.
Sir,
Paragraph 39 to 49.
got it.
Yes.
Therefore, may not I impleaded. Office may not raise the objection. Why you impleaded? That may not, because I said I attributed modifieds against the minute.
All right.
I impleaded.
What is the case law you are relying? Case law.
Yes, Your Lordship. That may not accept. Your Lordship, straight away take minute page number 3, 242, para 64 on.
This is 2020
Yes,
SCC
as Your Lordship may not want the latest one.
para
Para 64.
64.
Yes. In this minute, entire case law was reviewed. 64. Point number 6. There, my lord, the senior counsel Sibal raised an objection without impleading, my lord, persons, the chairman, Public Service Commission. You can't entertain the allegations. My lord, Supreme Court explained, my lord, what is the malice in law and malice in fact. Then, my lord, rejected his contention. Your Lordship, Sri Kapil Sibal, Land Senior Counsel, has emphatically submitted that in the expeditions, there are no allegation of malafide against the chairman or any member of the commission, and further, neither the chairman nor any member being included as party respondent by the writ petitioner. The petitioner could not have challenged the allegation of marks in vice versa, and there was no basis for any claim that marks in vice versa candidates have given academic qualification were deliberately reduced, and those who had poor academic records were deliberately given marks between 20 to 27 in the vice versa. Sri Sribal has placed reliance on the judgment of this court in so and so, where this court has laid down in the law cast a heavy burden on the person alleged malafide. This court has further laid down that when the petitioner's alleged malice in fact, it is obligatory for the petitioner to furnish the particulars and implead the persons against whom such malice in fact is alleged in para so and so. The law cast a heavy burden on the person alleged malafide to prove the same on the basis of facts that are either admitted or satisfactorily established and are logical interference deducible from the same. This is particularly so when petitioner alleges malice in fact, in which event it is obligatory for the person making any such allegation to furnish the particulars that would prove malafide on the part of the decision maker. Vague and general allegation unsupported by the requisite particulars do not provide any sound basis for the court to conduct inquiry into the veracity. In the state of Bihar versus P.P. Sharma, this court summarized of the law on the subject in following words, para so and so. Malafide means want of good faith, personal bias, grudge, oblique or improper motive or ulterior purpose. The administrative action must be said to be done in good faith if it is in fact done honestly. Whether it is done negligently or not, an act done honestly is deemed to have been done in a good faith. An administrative authority must therefore act in a bona fide manner and should never act or in an improper motive or ulterior purpose or contrary to the requirement of the statute or the basis of the circumstances contemplated by law or improperly exercise the discretion to achieve some ulterior purpose. The determination of plea or malafide involve two questions, namely whether there is a personal bias or an oblique motive, and two, whether the administrative action is contrary to the object's requirement and conditions of valid exercise of administrative power. The action taken must therefore be proved to have been made malafide for such consideration. Mere assertion or vague or bold statement is not sufficient. It must be demonstrated either by the admitted or proved facts and circumstances obtainable in a given case. If it is established that the action has been taken malafide for any such consideration or by fraud on power or colorful exercise of power, it can be allowed to stand. We may also refer to the decision of this court, Ajit Kumar Nath versus Indian Oil Corporation, where the court declared that allegation of malafide need proof of high degree and that an administrative action is presumed to be bona fide unless the contrary is satisfactorily established. This court so on. It is well settled that the burden of proving malafide is on the person making the allegations, and the burden is very heavy. E.P. Rayappa, state of so and so, there is very presumption in favor of the administration that the power has been exercised bona fide and in good faith. It is to be remembered that the allegation of malafide are often more easily made than made out of any very serious of such allegations deemed proof of high degree of credibility. In Krishna so and so case, the last refugee of the losing the litigant, there is yet another aspect of which cannot be ignored. as and when allegations of malafide are made, the person against whom the same are leveled need to be pleaded as parties to the proceedings to enable them to answer the charge. In the absence of the person concerned a party in his or his individual capacity, it will neither be fair nor proper to record a finding that malice in fact that vitiated the action taken by the authority concerned. It is important to remember that
That's it. So in case the requirement is that in case you are alleging malice in fact, then they are required to be impleted. If it's a case of malice in law, it's not. So we will decide whether 39 to 49 is a case of malice in fact and malice in law.
Yes.
In case it is malice in law, we will direct deletion. Correct?
that your lordship.
Yes. Mr. Krishnaiya, P.V. Krishnaiya heard in this petition, the petitioner has challenged the virus of Telangana VRAs, VR capital.
May it please your lordships, I beg to represent the view. My lords, the appeal is filed against an order of the learned single judge dismissing a writ petition for on the simple ground that there is limitation. May I kindly draw your lordship's attention to the impugned order that your lordship will find on page 10 of the materials.
Yes.
Whereas this relates to a correction of date of birth, I call upon the respondent, the statutory authority, to correct it in my favor in accordance with a decree to which it is a party. The lordships know that the learned single judge loses sight of the fact that I have been representing to them ever since the decree came. They are parties to the decree. There's a mandatory injunction against them. Therefore, a mandatory injunction against them and a declaratory suit in rem do not require execution. On that ground alone, the writ petition is dismissed. Your lordship would get it at page 10, single
Where is
paragraph.
the decree?
Page 31.
As prayed for means what is the decree? See,
Your lordship
It is
would
right.
find it, the judgment is at page, starts at page 10.
really, we are surprised that our judges are passing like these orders like this. Suit is decreed as prayed for. Right?
Yeah, that is the, yes.
We should feel inspired from them and petition allowed in terms of prayed for interim
No,
or
but I hope that it goes the other way around.
what is this? This is a declaration.
Yes.
Learned senior counsel for the petitioner submit. Yes. What implement, Mr.
On behalf of the Mirata, 1 to 4, controversy file, Mirata.
1 to 4 you have filed counter.
1 to 3, Mirata.
1 to 3. What?
Mirata, this
yes.
is Mirata, against fourth respondent, Mirata, please dismiss, Mirata.
Did not dismiss that, they did not consider to send the notice. Blood is coming for admission. Admission.
Yeah, but what is this like this? Why honorable head of the department? Who is head of the department of which? The chemistry department? Botany, zoology? What?
No,
Head of the department? How do you describe it?
which one?
What is, you are challenging Mr.
Yes, blood. HOD means head of the department of the Central Administrative Tribunal.
Please understand, you are challenging the virus of a provision, section 62B, right? So how this respond number 4 is this thing?
Yeah, that's it.
Respond number 4 has been implemented in his personal capacity.
But the reason that he is not qualified.
No, but you are not seeking a writ of quo warranto.
I am challenging the wires of the statute in which
In addition to Mr. If you one, all right, you argue if you can write an order and you don't want to understand even the query which is being put to you, fine. God only can help you. Go ahead. Yes, fine. Go ahead. We will not put any query to you. You argue. We will fix an order. Yes.
I'll alter that
Yes.
prayer. That's correct. I'll alter the prayer, madam. But with regard to, but I am challenging basically I am challenging the wires of the statute under which the appointment.
No, and this Mr. The uncalled for allegations have been, we don't know, you have made against him in his cap while he is acting as a member on the bench. So tomorrow you will, this has come to CAT. Tomorrow you will file a writ petition saying that a particular honorable judge of this court is behaving like this.
It is very unhealthy, Milord. All the allegations will not
Not
actually.
Mr. See, I mean, you are an officer of the court and we treat you with that utmost dignity. You have to behave like whatever Your client says even though he is 75 years of age and is an advocate, you should not do whatever he says that no, write this. You see, you are responsible for signing a pleading also. If you have signed it, we don't know. Right? This is what I mean. Is it in good taste we are asking you, apart from the legality and otherwise of this? We will put you to this. We have started with the prayer clause, you have sought time. So there are many other things we will ask you, but we are asking you that you are an officer of the court. Should you do whatever your client tells, do it. Stand up. What is the appropriate forum? You can resort to you can seek the relief of striking out of the provision, understandable. You can seek the relief writ of quo warranto, understandable. You think about it and we expect that by next date of hearing you will make appropriate application. Right? Otherwise, we will deal with it, whatever it is. Next question for the next time. Right? So, how much time do you want to amend the prayer clause?
1 week.
Learned counsel for the petition.
The petitioner says on behalf of the association. But there is no authorization from the administrative authority. Not even 10%. 150 members are there.
No. Yeah, 1 minute. 1 minute.
Individual capacity.
In the personal capacity,
So you correct the cost title. Then don't write president.
Also president.
No. Is he continuing as president?
No.
there is a revelation.
Delete. Learned counsel for the petition. He is not prepared to listen. What can be done? We can only pass an order. We will pass an order. Let him do whatever he wants to. Yes.
I'm extremely sorry, blood.
No. You must, Mr. First of all, develop the habit of listening to the court. Eventually, the court has to pass an order. You may think that I know everything. I can write an order. You write an order, give it to Mr. Praveen Kumar, sign it.
I am extremely sorry.
Therefore, you have to be with the court. You are not prepared to listen to us what we are trying to tell you. We told you something in very good mistake.
Sorry, blood.
We told you that you go through the averments made in the petition. What have you pleaded? Whether it is permissible to do so in a writ petition? That is the question we have asked. You are saying I am not getting it. Don't get it. The law will take its own course. If you don't get it, what can be done? No, nothing. Next. Yes. What? Yes, counter.
Counter file, man.
Right. 1 and 2. You want to file reply?
Yes. Short time.
Petition is admitted for hearing, learned counsel for petitioner. How much time?
10 days.
3 weeks time to counsel for petition.
May it please you. First, my apologies, my lords. Last time, you were not here when the matter was called.
We'll admit it has to be heard, right?
Yes.
Pleadings are complete, petition is admitted for hearing.
This matter is more or less covered by judgment of the Honorable Supreme Court, my lords.
Last time, my
Covered.
friend said he'll file a reply. He's just served the additional counter. He's just served it on me. If he wants to argue it on merits, Lordship may have it tomorrow, anytime, your Lordship.
We take it up tomorrow, my lord, because this is covered by Bank of India versus senior judge
In your favor.
in my favor.
My
Can't
conviction.
be like this, Mr. It's absurd.
Questioning the fourth.
The common sense, Mr. You know what is law. If you are open to listening, not like a previous council, then only we will tell. Otherwise, we are not interested in wasting our energy, right? What is law? Law is nothing but codified common sense, right? You test it by common sense, it fails. Like, can he be punished? I mean, whether a law would punish a person for no fault on his part? It can't be. Like, there is a stay obtained by somebody else. He is the highest bidder. He deposits 50%. Then he comes to know, somebody comes to, we are not talking about, somebody comes to know that there is a stay. He says that please give me time. So you will engage him in litigation also and take whole money from him also. And he will wait till infinity, till he dies, that his whole money will be with the bank. Bank will enjoy interest on it, will not refund along with interest. Supposing if the sale is set aside, and this thing, unjust enrichment, right, which law does not permit, is such a sort of an absurd situation. Can the law contemplate? Answer is obviously no. We will read that Supreme Court decision carefully. You also read it. It can't be. It can't apply to a situation where he doesn't deposit the amount due to circumstances beyond the control, or where there is a stay of proceeding by a court.
Petitioner before your lordship is the son-in-law of the borrower who has gone before the debt security tribunal.
Okay.
He has not come to this honorable court with clean hands.
No, that's correct, but there is a stay, right?
There was no stay because as on the day of the stay, it was already confirmed.
Facts different, Mister. We are on legal proposition. That
I'm on the petitioner.
You are on facts that there was no stay. If no stay, it will be dismissed. If he has not approached the court with clean hands, equitable discretionary jurisdiction cannot be invoked. That is a different thing. But we are about validity of security interest rules. It has to be read down. Like, it may not be in this case, but in an appropriate. We can't. Can you foresee a situation?
The validity of the said rule, Millers, has come up for consideration before the Supreme Court, Millers, in the particular judgment which I am referring to, and I also filed it along with the additional count.
All right.
That's the reason I'm saying it's covered.
Learned counsel for the petitioner submits that the If, yes.
7th, that Monday, if your lordships are.
7th
7th,
November.
oblige,
7th November.
oblige.
Yes, yes.
May it please your lordships. Your lordships, I appear on behalf of the petitioners in this case.
So representation is only to consider, the direction is only to consider your representation, madam, correct?
Yes, your lordship.
We will direct.
Second respondent filed a report, my lord, this
What report?
report, my lord, there is a seventh respondent issued, second respondent issued a consent, my lord, CFP and CFO.
Huh? The prayer seen the petition, mister, and you have given us a time schedule, right? So see the prayer, page 18.
Consider the representative.
We'll decide. You decide why to keep it pending. That's the only prayer which she has made. You afford an opportunity of hearing to R11 as well and pass an order.
Your lordship, may kindly allow me to make one submission, your lordship.
Yes.
Your lordship, the report that the respondent number 2 here in his file, it is the respondent number 2 has not conducted an on-site inspection, your lordship. However, there are specific.
See, madam, your prayer, come to page 18. What, page 70. This the prayer. We are granting your prayer.
Obliged, your lordship.
See you. Page 17 is your prayer. We are granting it.
Yes.
I am appearing for R11. I filed my comment.
No, not. We are disposing of the petition. They will hear you. Petitioner as well as you. Why this thing? The prayer is, see, page 17. Mark this thing. Presence with consent of the party.
Lordship, I am representing but R1 to R4, my lord. Lordship, kindly
which
type
rule?
counter, my lord.
May I please, your lordship?
We had asked you which rule you are entitled to additional quantum of pension last date.
Yes.
You had sought an adjournment. Now you are banking upon him that he is seeking adjournment on your behalf. You don't know, right? Give it to.
I'm ready, my lord. I'm aware of rule
Aware?
44, sub rule 6, my lord. Of
So
CCA.
please see this order, then tell us.
I'm aware of it. I was only representing last time also.
Please see this order.
Yes, my lord.
Which rule?
Rule 44, sub rule 6 of CCS pension rules.
Rule 44
Sub rule 6, my lord.
of
CCS pension rules.
Learned Counsel for the petitioner submits. Yes, Mr. Rao. Granted. Oh, Learned Counsel for Mr. Yes.
May I please? On the last occasion, your lordship directed me to issue notice to respondent number 4. I've issued notice. I've also filed a memo for proof of service.
Served.
Yes, my lord. She's appearing.
Appearing for respondent number 4. Appearing for
Yes,
filing a
madam.
wakalat today, my lords.
Again, wakalat and this thing next year you will.
We'll take it for tomorrow. It's for tomorrow, my lords. Please.
My lord, yes.
So this is a time bound thing, right? Relating to admission. Your
Indeed,
seat
madam.
is blocked. Still you are not in a hurry.
My lords,
You should be ready. What is the reason?
my lords, we are sailing with the petitioners, my lords. We are sailing with the petitioners, my lords. We've got instructions
Sailing?
written in. We have got written instructions.
No. Madam, this you did not, the grievance of the petitioner is that you did not upload his joining letter issued on 5/9/23.
Indeed, my lords.
So upload it and do, that's the,
No,
if you are not contesting, then don't seek an adjournment.
That option is not there right now because MCC has to open the portal. But now we have a communication from the DSG's office that MCC also gave them written instructions that if this honorable court directs them, they'll do the needful.
Who appears? Then why to keep it pending, madam? That's the thing. Like Friday it was listed,
Disposal of
again
direction.
this thing, again tomorrow. This waste
We
of
ought to
human
discuss
effort
it.
and this thing, no, they don't realize
Your lordship.
these people. If they are supporting you, then, Mr. Who is not willing to grant?
If your lordships may permit me to explain that aspect. In the third round of counseling.
No.
Can-
See, the case is Mr. Praveen Kumar. He or she, we don't know, was allotted a seat under DNB quota in orthopedics in respond number 4 college. And a provisional order of allotment has been issued on 30th/8/2023. Thereafter, the grievance is that the respondent number 4 college did not upload the joining letter, due to which the process of admission could not be completed. So, I don't know, she is like, so last date of hearing Friday, we granted an interim order and we said that the respond number 4 college should be served. So,
Your lordships may permit.
college says,
Filed undertakings of the candidates who were given in round 3. They are saying that if round 3 candidates give any form of undertaking, round 2 candidates, who are the petitioners herein,
we
will
don't
be given
know.
the seats.
What? So, no, we are, so she gives us an impression that your claim is not being contested. She is also saying that I am sailing with the petitioner. So then we were saying that if nobody is contesting the claim of the petitioner, then why it should be adjourned? That's the only query.
We've also given them the NOC of those third round candidates.
Huh?
Your Lordship may pass it over.
All right. Pass over. Same, 16. Oh, yes.
But we have filed.
Everybody has filed.
We have filed included applications. Included applications are.
Mr. There is already an order saying that it will be considered at the time of hearing complete. But we are asking before proceeding to hear the counsel for petitioners whether pleadings are complete.
As far as proposed respondents are concerned, my lord, no counter is filed. Counters are filed last occasion by the government and also my lord,
Private respondents do not, you make a statement, then we go ahead. She is mentioning at 10:30 it should be heard.
party respondent.
There is already an order.
Last occasion you last dictated, we have seen that.
We did not dictate, it's already the erstwhile bench passed an order. Which order, madam?
See, there are two sets of respondents, the pleaders. My lord, file 29 March 23, where IA 1 to 4 are taken up. And in fact, the court's order, if I may read it,
Who is NTR? NTR is here. It says further here.
NTR and monthly application numbers.
yes, this one.
See, this is what the argument, the order is, Mr. That's what we were telling you. This thing, the orders have been passed, like arguments made on behalf of interveners have been duly taken note of. The same will be considered at the time of passing.
We have filed
Two sets of.
my lord, we are the people who participated in the session. I am appealing for 3 persons who were at, there were the past tables who filed at them, my lord, and they filed to stand away and then run away.
Ah.
So, my lord, against that, there is a report by the commission.
No, see, Mr. One by one we have to take, you cannot start addressing.
Please say.
1 minute.
Yes.
So you are appearing in 173 PIL.
No, my lord, we're not party in 173.
Yeah.
Not in 170.
Then,
Yes.
right, one, so.
Yes.
Status filed a counter.
And then, who else? There are,
We filed impleads, your lordships, on behalf of the council. We filed impleads on behalf of the people against whom the inquiry report has been submitted, your lordships. The inquiry commission as well as the final report. We are the necessary and proper parties, your lordships, because the entire report is on us and our action. I filed implead for the supervisors of the handlers, your lordships. I filed in 174 to 1, including the writ petition filed by the petitioners, your lordships. From 17 to 23, I filed impleads, your lordships, on behalf of the people against whom this all these public interest
People means
litigations have been.
police officers.
Police officers.
Yes,
Police officers.
we represent the police officers, your
My
lordships.
lord, there is a court.
Sets of the
one
police
minute,
officers.
listen, so you have filed implead.
Yes, your lordships.
Who else?
173.
I'm also appearing, but I'm not.
Yeah, my lord,
170.
if I may be allowed to assist the court, because
Yes.
the matter has been
Yes,
many.
yes.
My lord, it's a batch petition.
Yes.
First was a representation in the form of a letter, which this honorable court took suo motu on the date of the encounter killing, and that is 173 of 2019, in which I am appearing, my lords. My lords, in that, none of those who were part of the raiding party or those police officers are not respondents. They are respondents in 46884 of 2022. Date of filing of that writ petition is very material. That is December 2022. My lord, this matter has come back on board of this court because of a specific order of the Honorable Supreme Court on 20th May 2022. At that time, this writ petition was not there. If we may just take, my lords, to the order of the Supreme Court, which brought this matter back on the board of this Honorable Court. May I have that indulgence, please?
Yes.
Please, my lords. Give me that order, please. I've placed it in my compilation to the court. Open the order of 20th, please. The last order of the Supreme Court. Para 6 of that order is the relevant paragraph. As to who will be parties before the Honorable High Court now. No, 20th, no. Yes. It's at page 10 of my compilation.
Madam, the other one. Yes, yeah.
The thicker compilation. Volume 1, page 10. My lords, in this petition, because this was the case by virtue of which the Commission of Inquiry was constituted by the Honorable Supreme Court. The Commission returned its report to the court, to the Supreme Court, and of that date, the relevant paras only I will read. Para 4, my lords, on page 13, bottom of page 13. Please, my lords. During the course of the hearing, it was brought to our notice that a PIL regarding the same matter is pending before the High Court of Telangana. However, because of the pendency of the present petition before this court, no orders were passed by the High Court of Telangana. In view of the fact that the commission appointed by us has already completed the inquiry and filed the report, we are of the considered opinion that it would be expedient for the same to be taken up the High Court of Telangana in the PIL pending before it. We therefore direct the registry of this court to immediately transfer the entire material forwarded by the Inquiry Commission, including the report, to the High Court. Parties would be at liberty to make their submissions before the High Court. After considering the submissions of the parties, the High Court is requested to take appropriate action at its end. My submission before my lords is that this is now in the pending PIL, which is 173. And there were some other petitions filed in 174 to 183. The petition in which respondents are now appearing, apart from the state, the private police respondents, was not a petition pending before this honorable court. This honorable court is only looking at what are the directions to be passed on the basis of the Commission of Inquiry. There is neither a trial nor an appeal presently before this court. It was a limited mandate and a direction given by the Honorable Supreme Court. Thereafter, 46884 is filed by the deceased victim families of those who were killed in the encounter, the 4 men. And in that, all the policemen, along with the state, have been made respondents. They were never before the court. My lords, even otherwise in law, would the proposed accused be part of, and there is settled law on this, would they be heard? And the only prayer we are seeking presently is registration of an FIR under section 302 IPC, and who will investigate. Those are the only two issues which this honorable court is examining. At the time of hearing 173, 4 impleadment applications were filed. My lords would now have the order of 29 March 2023 of this honorable court. Please, my lords. IA number 1. This is filed by the father of the victim woman who was murdered and raped. The interlocutory application has been filed by Mr. X, father of the victim Disha, for impleadment as respondent in PIL number 173. Since this proceeding is in the nature of a public interest litigation and not adversarial in character, we are of the view that it may not be necessary for impleadment of Mr. X as a respondent in the proceedings. However, we have heard the applicant as an intervener in the proceedings PIL 173 of 2019. Mr. So-and-so, senior counsel representing the applicant, has made elaborate submissions, including on certain aspects of the report of Commission of Inquiry, a 5-judge bench of the decision of this court regarding procedure to be followed in investigating police encounters, and the related order of the Supreme Court dated. This is in the Andhra Pradesh Police Officers Association, and he has taken the court through the decision of the Supreme Court in People's Union for Civil Liberties versus State of Maharashtra, as well as full bench decision of the Madras High Court. Arguments made on the behalf of the intervener have been duly taken note of. The same will be considered at the time of passing of final order. The court has not impleaded, but has said that all arguments have been heard. Similar orders. My Lord would then see IA number 3. On the next page, it says, with respect to IA number 3, and in IA number 3 is filed by the retired police officer. This is now the Retired Police Officers Association. This interlocutory applied by Retired Police Officers Association of Telugu State seeking impleadment. Similarly, the court heard the learned senior counsel, and at the end of which the court said, arguments made on behalf of the intervener have been duly taken note of. The same will be considered at the time of passing. IA number 4 is by an officer of police station, Shamshabad Police Station, in which again, similar orders that we have heard the arguments, we will take them into consideration. My lords, in IA number, there's one more IA number 1, no, IA number 1 is here. IA number 2. IA number 2 is filed by the Telangana State Police Officers Association. I have even filed a reply opposing the impeachment, and that is pending. That has, I don't know whether it has been argued. It has also, that has not been heard. That's why there is no order pertaining to I. But this is the nature in which the predecessor court had dealt with the IAs. Insofar as it is only on the occasion of, and I will have to mention it, the last orders passed by this honorable court, finally the state has filed the counter in a matter pending since 2019. The counter is now on record. We are actually at a stage where we can perhaps move forward. Insofar as these private respondents are concerned, who are police officers of different ranks, some part of the encounter party, some the supervising officers, they have all come into this case through writ petition filed in December 2022. It would be my humble request to the show that order, the order what by which the notice was given. We just had it. It would be my humble request that insofar as that matter is concerned, while notice has been issued, I will be failing in my duties if I didn't point that out. On 21st June 2023, an order of this honorable court, where the court says that notice is being issued, and this is where even the pleadment applications are brought in by 21st June. My lords, would that petition be part of what has been sent to this honorable court by the order dated 20th May 2022 by the Supreme Court, with a limited prayer of hearing the parties who are already before the court in the earlier FIL, and seeing what appropriate actions and directions are to be given on the basis of the Commission of Inquiry report. Because all those others are matters of trial. Right now, we are at a very, very preliminary stage. So my humble request would be if it can be de-linked from PIL 173, if this honorable court can decide the fate of the Commission of Inquiry report, the other matters can be pursued. They have multiple remedies in law. That would be my.
What are the other petitions about?
My lords, it's 46884. Where is the petition? I am just, I think one of the prayers, my lords, is also for compensation because those killed in the encounter were, no, 46, this is the petition. The prayer
On behalf of those persons who were
killed in the encounter. Yes.
Their family members have filed.
Please, my lords. Please, my lords.
And in your writ petition, like which has been remitted by Supreme Court, the scope is, you said, as you said, what action, further action to be taken?
On the report.
Report.
Please, my lords, on that, these are legal arguments.
Yes.
In PIL 173, which was pending, which I had mentioned when the matter was taken up that day.
So, but we'll have to hear the proposed interveners in your case also, because the bench, they said that arguments on behalf of interveners have been taken note of and suitable orders shall be
My lords,
passed.
Court refrained from impleading them.
Yes.
But
None has heard them. So that's what we are saying, that even though technically they may not be like formally, we will like, yes, we will hear them.
These are all legal arguments. There is no difficulty.
We can hear them.
Please, those are four impleadments by the Telangana State Police Officers Association, the Retired Police Officers Association, the father of the deceased victim woman, and there is the CI, the Circle Inspector of Shamshabad Police Station.
So that we can, yes. What do you say? And this thing, Mr. You are one of the 40.
In fact, I was the first to impeach Lordship have seen the order of Chief Justice Bhuyan. That was the order passed in my case. So, my lord, as far as implead is concerned, that order is passed. I am not going to make further arguments.
Okay.
You can be heard like when, like, so can we go ahead? Tell us.
Only for Lordship's convenience, I made some note, my lord.
Yes. So you are for one of the implead this thing, you are appearing for proposed this thing, parties in one of these matters.
And I was heard, and my lord, that's the order.
Yes. So we will hear you. I mean, there's no problem. Like this position has been fairly considered to by her, that we will consider, and you may have a point of view. We will consider that arguments. It's a legal issue. So we will hear that. No problem. Yes.
We can also be given copies. We'll also assist the court accordingly. Please, Andre.
Please.
So, yes, can we go ahead?
These people are appealing, they are the sub-inspector and inspector who are the party on the day. But whereas 20.54, the commission says they should fight for the offense of 3 So we questions questioning the very report itself says that the Honorable Commissioner appointed Supreme Court says that we are not even entitled for statutory products. Kindly see that 20.54 of the commission report. That's why we are finding that subject inspections question.
So you will be heard, right?
We have to implement what is point, but I know because the prayers of respect of us. Now they
My lords.
now my opinion. First matter. 173 is taken up by KG. Based on the data. Now, in all the applications, we find the applications, just we have to go to press.
So, like, see, you will also be heard, right? And there's no problem.
So much said about us. Not only in the meetings and in the inquiry report. Inquiry report, you have to carry one paragraph where options are there. 20.54 next week and certain.
No. So in 1 minute,
The terms of reference. Why is
173, you have filed an application for implementation.
She is not appealing in 170, she is appealing.
No, I'm appearing in 173 since 2019.
Yes.
And that's not a correct statement.
It's the proceeding.
Yes.
No. Arey, 1 minute. 1 minute. We are trying to just ascertain in which case your application for implement is pending. Simple.
All other applications.
All other petitioners. Who appears for petitioners in those cases?
That is why I've got that is why
Your lordships, if your lordships may,
Who appears for petitioners in other petitions where he has filed implement?
your lordships, even we have filed implements from 174 to the writ petition, your lordships, and we are the people actually affected. We are the people who have been charged with 302 in the alleged encounter, your lordships.
My lord,
We have filed these impleeds in June 2023, your lordships, along with, because here, your lordships, the challenge is to the Commission of Inquiry report, your lordships.
My lord,
We have filed separate, allow me to speak, ma'am. We have filed separate writ petitions challenging the commission of inquiry, and we have impleaded ourselves into all the public interest litigations, your lordships. I represent two people who were the supervisors of the.
Correct, madam. Your application for impleadment is
Yes.
pending. We are asking who is appearing for petitioners in remaining petitions? Nobody.
I appear in 173 and 183.
173 and 180.
Nagraj is there with me.
All right, yes.
183.
So, you have, this thing, you have received the application for impleadment filed by them in 183.
Absolutely, I will be allowed to assist because we have WP field PIN, except IA number 3, we have received all the implement applications.
We have.
Which 173?
173, we have also filed a counter in IA number 2 of 20.
No, just on.
And what about 183?
Yes, your lordship, I have received all.
All this thing and you have filed counter.
Counter in
Would
one.
you like to file counter?
Please, my lords, I would like to file a counter because what is with a challenge to the Commission of Inquiry report is not a matter upon which this learned court is presently adjudicating. So therefore, if whether, and we'll have to go back to the terms of reference set by the Honorable Supreme Court, which says.
So what we do, madam, yes, what we propose, madam, that you file counter
I will do
to
that.
this thing, IAs in 183, and then we hear you on the next day.
I'll file a joint.
On this, we will decide this, whether impleadment has to be
I
done.
will be allowed to file a joint counter because there'll be some preliminary issues which will have to
All
be
right.
decided.
Yes,
And thereafter, a synopsis will also be filed.
yes. So how much time?
My lords may take it up. I have
183.
personal difficulty this month. If it can be taken up early next
When-
month,
Yes,
if it is convenient for the court.
yes, yes, which date?
My lords would. Seventh. My lord, would 7th November or I will just. My lord, 2nd or 3rd October, I don't know.
November.
Yes. 2nd or 3rd November, I did.
2nd November is Thursday. Yes,
That be convenient?
Third, Lord, I have 26.
2nd November,
2nd is convenient?
2nd November,
Yes, your lordship.
mark the presence, learn it is, second November.
And yes, your lordship. I have it. Deeply
You
obliged.
be ready
Yes,
on
your lord.
2nd November, whatever. And madam, in case you give us a synopsis like this, so it will, yes. So it will
Yes.
cut short the time, that's the only.
And a synopsis of the legal.
Yes, yes.
Please, my lords.
I already passed on to lordships.
Ah, yes.
This, my lord, and
Where is? Staple it, madam, in this file. Staple. Huh? Staple it.
there you
All
write
right.
me all the cases, the prayers,
All
the
right.
intentions, everything I've read.
Yes, 2nd November.
I'm grateful, my lord. Grateful, your lordship.
Staple. Okay. 22 to 17 to 22. Huh? 23. Next, 24.
This matter, my lord, we have filed counter, my lords.
Hmm.
In fact, my lord, action was initiated with respect of the illegal construction which is carried on. But what had happened, what had come to the notice of the respondent, to the counter have said so, that there are two independent writ petitions which are filed by the parties aggrieved. The action of the respondent.
Probably your stand is that if the report is submitted by Dundigal municipality, based on the report, the action will be taken, right?
No, in fact, the counter which I filed to the Tahsildar, it says we have taken action. Subsequent to the action being taken, two writ petitions have been filed independently by the parties aggrieved. Interim orders are passed by this honorable court, the writ petitions are pending.
Which?
But I'll just bring it to my lord's notice, WP 22063 of 21. 22063 of 21. WP 38032 of 21. 38032 of 21 minutes. 21. And 25151 of 22. 25151 of 22. 22. Yes. There, my lord, interim orders are passed by this honorable.
Mr. Harendra Prasad, Learned Counsel, submits.
For the
Yes,
petition,
madam.
the matter, your lordship, respondent number 2, 5 and 6 have filed the counter, your lordship. Other official respondents have not yet filed counter, your lordship. It's a bill challenging, your lordship.
What about 1 and 2? Mr. Praveen Kumar, 1 and 2.
3 and 4 I'll counter. Proposal respond number 2 and 5, 6 you have 5 counters.
2, 5 and 6 have only.
And others private response also there.
So they have taken action, madam. Have you gone through the counter?
Yes, your lordship, gone through the counter, your lordship. That's why I'm making the submission that it is necessary that other respondents do file counter, particularly the state and the union, your lordship.
If the respondent already have filed counter, your lordship.
Madam, you don't appear for state government, right?
State, we have filed only authority, your lordship. R5 is the drug controller, your lordship, not the state, your
Madam, we cannot force them to file counter, right? Whatever advance inference will be done, they are not saying anything.
Your
You want to file reply, otherwise
lordship may forfeit the right of the respondents who have not filed counter. I'll file my reply and argue it on the next week, your lordship. Because I've gone through it in
they
detail.
will not say anything. They are still the state of affair, still comprehending what is what. Mr.
lordship,
Praveen,
the record-
you don't want to file reply. 1 and 2.
1 and 2 put it.
No, say so. They don't want to file. Then we go ahead.
Yes, your lordship.
The appeal for respondent number 2 has filed this counter affidavit.
You are fine, right?
Yes, 2 and 6
So you are what?
For respondent 2 and 6.
You adopt the counter of respond number 2. What is there? Mr. Praveen Kumar, Learned Deputy SGI submits. He adopts the counter filed on behalf of respondent number 2. Mark his presence. How much time? Then not next week. This is not the only case on the file.
Your lordship, I would ask.
We have admitted. How much time do you want? 2 weeks. May file. She's not saying it.
I think there is.
I'm so grateful.
We got to the food side. My lords, may make. My lords, for response 1 and 2, we have filed counter, my lord.
1 and 2.
1 and 2, my lord. For 3, we have to file counter, my lords. For SSC,
3.
I request 2 weeks time.
This is, no, but notice has not been issued. We were asking him what.
My lord, in March, the exams are.
No, you remember we asked you what should be done like.
My lord, I'm having some sinusitis, my lord.
Huh?
These are some preventive measures, my lord.
What preventive? No, we are all serious about it.
Yes.
Like, I mean, it has to be done undoubtedly. They will not contest, but what should be done? We should have an idea.
As per their counter, my lord, in page 10, my lord.
Counter?
Filed
For intermediate,
filed the counter, my lord. Page 10 to 12 material.
No, have you filed this thing? Precautionary steps which can be taken?
Yes, my lord.
Where is that? Where is that? What have you done?
All these suicides are within 5 to 10 hours after the results are released. Lord, this is, these are not so pre-planned, my lord. These are happening within.
Nobody can pre-plan. Pre-plan it that I will do it
Yes, my lord.
within 2.5 hours of declaration of result.
Sudden provocation and all aspects, my lord.
Sudden provocation by
Disappointment, not provocation.
Yeah,
Means the
actually.
relatives and they will say, you have been failed, you are nothing. You are
No, the student who do not study whole year, they know what will be the result. So it can be pre-planned also. Like the student not studying anything, he knows how will he perform, so he can probably pre-plan.
From second point onwards. I see.
Yes.
One of the primary factor contributing.
Which were?
Second page of second point.
Para 2.
Yes.
Yes.
One of the primary factors of contributing to this tragic event is sudden and disappointment of students' experience when they are having believed.
Arey, Mr. What is draft counter affidavit? You have filed it like this? Huh?
my lords, I have site counter.
Huh?
I have the counter which is signed, my lords.
The sign means draft counter affidavit by 1 and 2. So far. Heading. You what have you filed?
But that's a mistake. It's a file counter, my lords. That's a mistake. I'm sorry, my lords.
Don't be so callous that nobody sees draft counter affidavit. Thereafter you will say that I'm yet to file counter affidavit. It's only draft.
Sorry, but that's a mistake, my lord. Very sorry.
Correct it, Mr.
I'll correct it.
Correct it. Sign it. What is this? Draft counter affidavit. You have signed it?
Yes. My lords, para 1 onwards, my lord, first page, my lord, we have mentioned what are the steps taken by the government, my lord.
So what has been done? Like this you have issued, right?
But this is regularly happening, my lord. Meetings, my lord, in every college there is a counselor.
What is this thing subsequent compliance report that just issuing means colleges have been following it or not?
Yes, my lord. Regularly these programs are happening, my lord. My lords may kindly see page 2, my lord, all the managements, the second paragraph at the end, my lord, we have mentioned, all the managements of the colleges were instructed to strictly follow the following guidelines.
No, no, are they following? You make a statement.
I'll submit, my lord, status report, I'll submit. But I'll have to file counter for third response also, my lord. SSC, third response I have to file counter, my lord. The SSC board.
Mark the presence. The issue in this, no, the grievance, the issue in this petition which has been filed as public interest litigation.
Of mental health sciences, my lord, they extend classes in every college.
Respondents number 1, paragraph. Respondents number 1 and 2 have filed a Whoever wants the bills to be declared, that doesn't declare all the issues. The students wants to declare news like the results to be declared. And those results are only declared. Arey, Mister, come here. See, you don't think about it, right? You are not think about brother has pointed out a brilliant this thing. So, like the results of only those students should be declared who wants their results to be declared, right? And no, sir, this is valid suggestion in the sense that supposing if I am a studious person, I have done well, I know that I will be scoring above 90%. I will say yes, my result be declared. You don't study. You know that in all subjects I will fail, I will have to repeat. So you will tell the board not to declare the result, please communicate it to me only. So your relatives will not know, parents will not know what has happened. So that pressure won't be there. Correct?
Yes,
You think about it next date.
Perhaps a communication of result by email must be, I think.
That can also happen.
Yes.
Think about it.
Yes.
Think about it. No, that's what we are saying, that you should, once you file PIL, you must come up with brilliant ideas. Right?
My lords, with my lord's permission, Lord, in fact, this issue has come up in a movie, my lord, where in a movie, my lord, in a lighter vein, my lord, it was.
Movie?
Yes, but the suggestion was that display of results in the notice board might upset the students. So it must be communicated personally to the.
Personally.
My lord, there are many.
You know which movie he is making a reference to, you know, right? 5 point someone.
Yes. Oh. Obliged, lords.
Yes.
State was directed to submit a report after the inquiry is completed. Since instruction on the inquiry was on then, last occasion, I need to place the report for the school. Inquiry in respect of the officer.
That we know, but we are waiting for his response. He is the petitioner.
I thought I should respond only after my friends.
Yes.
Because the ball is now in AG's court. Now what happened is, the last date of hearing, it is not present, can be deferred. There are some applications can be disposed of so that unnecessarily we are showing so many, so many IAs. I'll point out. I have made a note, I'll point out. So far as learned AG is concerned, I just wanted to convey because today he is not there. In the counterfeit filed by them, there was that on what date of hearing the AG said he'll have a look at the charges framed against this officer. In the counter affidavit now they have filed, they say AG has addressed a letter to the disciplinary authority saying that whatever is framed is enough, it need not be framed. That type, that we don't know, because what AG has communicated to the disciplinary authority, the charge officer is giving a reply. We have a counterfeit. He is extracting the letter addressed to the chief secretary. In his counterfeit, the charge officer was better.
So AG is not there.
AG is not there. But my instructions are, the instructions of AG were otherwise. I am not sure. They say, the spectators know better than the players.
Should have it next week or
Next week?
2 weeks later.
Next week will be Monday will be.
Monday, next Monday?
2 weeks.
Sir, 16-10?
Go after vacation.
2 weeks.
2 weeks will go after vacation.
After vacation.
Just to give a report, just to give inform us what is happening.
So can it come up on 16-10 or 17-10, whatever date?
17th.
17-10.
But some IAs which can be disposed of where there can't be any controversy. I'll just point out so that they can be closed.
Yes.
But the Lordship may kindly have looked at writ appeal number 656 of 17. But those IAs can be kept pending because they are disputing. In WA 686 of 2017.
Yes.
But I have filed IA number 1 of 23.
Implead.
To implead respondent 16, he is the disciplinary authority, so he is required to be impleaded.
Yes.
He is the secretary GAD. Because directions will go only to him. Directions will go to him only because we can't.
We'll decide it on next.
He is opposing.
Yes. Learned. Mr. Harendra Prasad Learned, so and so praise for accommodation.
fact, we can pass it.
Yes.
May I please your lordship?
Pass on the yes,
yes.
so that it will have a next time.
Yes. Keep it, staple it and keep it.
Then.
Staple it in the main paper book, staple.
Just because we find that your lordship spends a lot of time in reading the.
Yeah. Thank you.
That's what I will tell my colleagues.
Thank you.
It's convenient for the honorable court.
Yes, yes. Thank you.
Nice.
May I please your lordship?
Yes, Mr.
Great
Prabhakar.
respect to the Honorable Court.
What happened?
Lordships, I am pressing interior prayer that Millard, to advise minimum wages advisory board as recommended to issue the GO. But has been issued, Millard?
We are not against the.
No, not against means when will you do it? That's the question. Not against.
Your lordship kindly.
Nobody can be against law.
Your lordship kindly grant us 3 months time that we'll do.
No, Millard, they are.
Because non-publication has been explained in my talk.
Millard, your lordship.
The public, see, Mr. Prabhakar, you always raise genuine issues and there is no contest, right? And we, 1 minute, we will not permit the other side to contest the issues raised. I mean, that in 73 scheduled employments, revised minimum wages as per the act has to be granted. I mean, this nobody can argue and we will not permit anyone else to argue. He knows it. We are only trying to find out the modalities, how to implement it.
Yes.
There's no this thing, right?
That is enough to me, Millard. That is enough to me, Millard.
Enough.
Yes.
See, the reliefs which you claimed for flood victims, we granted or not. We told you in that case also. All we are sitting here to see to it that all benefits accrue to the flood victims. We will not permit them to contest. How can he argue that we will not pay minimum wages? The only thing is how to do it. That's what we are asking him. He is not saying that I will not do it. He can't say. He is an officer of the court. He cannot say that we will not. Yes.
We are considering it, your lordship.
They are not considering. So what?
Some reasonable time may be granted.
What reasonable time?
Because when the GOs were issued, enhancing the minimum wages, certain objections have been filed by major industries.
When GOs were issued? And when the objections were filed?
Now that the GOs have been withdrawn, we'll reissue the GOs within 2 months, your lordship.
That those have not been revoked. Now they are trying to revoke it. Their objections were scratched and issued the GOs and not printing. And recently, illegally, ruling party chairman has been appointed. Now he is trying to revoke the same.
Where is the prayer? Like, see, orally you are saying you make an application, we will grant it.
No, Millard, interim prayer have already been categorical stated, your lordship may kind see. Your lordship, my interim prayer, Millard. Your lordship may kind see my interim prayer.
Published GO.
Yet, lordship's at page 37, Millard. In the year 2021, they have been issued, but not printing the gazette, Millard.
Yes, Mr.
Once it would not be printed.
2 years have passed.
We'll issue the 2 months. 2 months time.
4 weeks.
Very well.
4 weeks.
Very well.
Hard, learned. See, there is no scope for you to argue, Mr. Nobody can say that, I mean, it can't be.
Yes, I'm deeply.
Mark the presence.
print this,
unless
valid in the eye of law.
unless your lordships are aware, unless the GO has been gazetted by due publication.
So you have to gazette it. No?
We'll do that, but they have to be revised. If they are revised, if they have any grievance, they can as well come before your lordships.
All right. So on the other hand, learned so and so shall submit. See, Mr. We have said, but they will take an action to revise, and such a revision they will take an action to abolish, to publish this thing in the Gazette, and such wages, revision of wages have to be in accordance with Minimum Wages Act. This is the prayer. This is the prayer in the petition, Mr. Let's see. First.
Oppressed. Deeply oppressed.
Yes.
This matter, madam. 7 lakh people are discharging their duties in the across the state, madam.
Yes, that's right.
Submission.
Correct. That's why we have said 6 weeks.
Very poor people, my lord, their livelihood is deprived from 2012 to till today. They didn't print the gazette, my lord. That is.
Now there is a time-bound direction.
I'm deeply oppressed.
Yes.
Counter has been filed, item 31. Counter has been filed.
Pleadings are ready, my lord. I filed an application 2 of 2023, my lord.
In this case,
this may be ordered, my lord, to measure the lands of the petitioner, that is a school, as well as the land of the respondent number 7. Thereafter, your lordship can dispose of the matter, my lord. Call for the report from the district collector. They also filed the all pleadings are.
What is your grievance that these people are raising construction on the land belonging to school?
School.
Who?
This is the 7th respondent, my lord.
Respond number 7.
my submission lordship in this case,
Without any survey number, my lord.
7th respondent. It is a civil dispute and pending before the Honorable Civil Court, and my friend converted the political interest litigation in public interest litigation.
How political?
Yes, lordship.
What?
Yes, lordship. WP number 34686 of 2022 is pending before the Honorable Single Bench. I have filed IA to the.
No, what is political interest?
Yes, lordship. The husband of the 7th respondent is elected was deputy sarpanch. All the other members of the panchayat has made an application for no motion confidence and removed from him from that post. And all these political rivalries are going on since 2021, lordship, when he was elected. And it is my submission, lordship.
No, what is political? Is your husband is Up Sarpanch.
Yes, lordship.
What?
They are, lordship, they are playing all these tactics against my
No, they means to.
from him.
How you said, I mean, it's very easy to say something and not to substantiate. What is, you said it's a political interest litigation.
WP number 34686 of 2022 may be clubbed with this petition. I have filed counter in IA number 2 also, lordship.
We filed the reply also, my lord.
So what, we will admit it, there is a stay already. A petition is admitted for hearing.
Before that, my lord, my request, my lord, report may be called from the district collector. The matter can be disposed of later, my lord. Where is the land of the plots of the 7th respondent? Because in the registered side lead, they don't have any survey number. Where the school institution got the survey number, my lord? That is the difficulty.
Where is the IA?
IA 2 of 2023, my lord.
Have you filed counter? Nothing.
Yes, the file counter also, my lord.
I have filed counter.
So what is the prayer for opposition? If you are not, your contention obviously cannot be that I will construct on this school. You must be saying that the school, the land belongs to me, right?
My submission, lordship.
No.
Survey already conducted by the survey and land records, and there is a school consisting only on 9 hectares. My submission, Lordship.
Arey, Mr. What your case must be that I am raising construction on my own land, correct? Not belonging to school. Or you are saying that you are raising construction on land belonging to school.
Counter says the land belongs to education department, my lord. Constructions are without permission, challenging which he has filed an appeal. Appeal has been rejected, challenging which he had approached a single judge, my lord, which grant stay of demolition. Even that has been tagged on now.
No.
Yes,
What
if
is
the
his
survey
case?
conducted, if the
The
survey
survey has been conducted.
Survey is not conducted by any authority, my lord.
He is saying, when government advocate is saying you.
No, I'm not.
And then you say that he is making an incorrect statement.
No, if the survey is conducted, the truth will come out, whether he is in the, even he is constructing without
So
permission.
who is the authority conductor?
Made an application to conduct a survey through.
Who is the authority, Mr.?
Sir, Assistant Director of the
He's not
Survey
big
Land
party,
Records.
he's not party.
In the jurisdiction of.
Not a party.
Collector.
So you carry out the
Yes.
survey.
Yes,
Huh?
yes,
All right, mark the presence.
we have that.
The grievance of the petitioner in this public. Time we will speak, right? Don't try to this thing simultaneously. You write an order, give it to them if you can. Who will?
May I submit?
They are telling you, you will not say anything. Right? You said political interest litigation. You said my husband is deputy sarpanch and did not say anything. Our petitioner is related to your husband. You didn't say anything. Then we asked you, what about sir? He didn't say anything. He said that you have filed a petition in which it has been found. Is it not found against you that you have raised construction on a school playground and there is an order of demolition? And then you have challenged that order in a writ petition which is pending before us. Then We are ordering a survey in your presence. What is the problem? You should not oppose it. You don't understand, Mr. What to do. I mean, we have to make submissions on your behalf, record, then meet it out, then explain it to you. Why you should not oppose? Because there is already a survey against you. You are getting a second opportunity. You should not oppose. Simple thing. Just it is said, everything court says has to be opposed without realizing that it may be in your interest. First survey report is against you. We will rely on that survey report, delete. So we will rely on the survey report in your petition and dismiss your petition also and allow this petition. Right? Because the survey report is against him, no?
Yes, he is constructing without permission.
My permission, Lord. As per survey report, there is a civil dispute is pending.
Mr. We survey report
consisting on 19 guntas.
1 minute, please understand. We only tell brother, tell him the difficult.
I invoke submission, Lordship.
That we are
Page 3 of my
counsel,
counter.
the construction is on the government land or not. That that's what we want to do. He doesn't want to understand. So this, see, tell him.
My submission, Lordship, page 3 of my counter.
You follow.
See, there is already a order on 4/4/2023 directing no further construction activities to be permitted. Now, what is your grievance? If
Construction is already completed.
If you don't want to listen, this. Okay.
Construction is already completed, Lordship. Construction is already completed.
Now, what is your grievance if a
So it will be demolished, right? Don't worry, it will be demolished. If it is completed, we will see to it is demolished.
Page 3 of my counter may be seen, Lordship. Paragraph number 5. As per survey conducted by Inspector Survey ITT District Survey and Land Reports and issued the report in the file number A1/839/2022 dated 17/10/2022, stating that total extent of survey number 638 is 6 acres 36 guntas. Safeguard collector register not available. As informed by Tehsildar Domagunda, according to Pan in 638, there is patta land. Out of 6 acres 36 guntas, acre 110 are marked as school and 20 guntas for road. But in respect of this particular, there is no evidence on record. There is no supplementary safeguard. In respect of school land subdivision not done. In respect of lands which are not subdivided, extent will not be mentioned.
Tell him what we are trying to do. He is reading. Tell him.
Have you followed the directions of the court?
Yes, Lordship.
What are the directions which you understood?
Orders to survey the land again.
Okay, what is your grievance if a survey is conducted?
Survey is already conducted. It is my
No, if a second survey is conducted, what is your grievance? Then why are you arguing?
I apply. It may be recorded my submissions. That is my.
That goes without saying. You have already filed a counter. At the time of passing the final order, those pleadings would be considered.
I apply.
Nothing but you are wasting the court time.
Lordship, on submission, my lord, it is a assistant director, my lord, not assistant surveyor.
Assistant director.
And director.
You tell the name of the officer, Mr. We are not aware with the designation here.
Assistant director, not correction.
Assistant
Director of District Kamareddy.
Assistant director,
Assistant
survey land
Director
records.
Kamareddy.
District.
What?
District
Assistant Director what? Of Survey Department.
Survey and Land Records.
Yes, Assistant Director. None for the petitioner even when the matter is called in second round, it appears. $15. Yes. What?
230.
What 230? Why?
Petition comes also that my panel counsel is there.
Huh?
My panel counsel is there. Here,
None for the parties, none for the petitioner when the matter is called in second round. List tomorrow. However, taking into account the nature of controversy involved in the petition. That means there is no urgency in the matter because
I think she was sitting
we have granted an interim order. That's why.
I think she was sitting and preparing something, my lords, that's what.
Yes.
My lords, we have compiled, my lords, certain document and a synopsis also, my lords, I'm just
We were told that you are not here today. One case and adjournment was sought.
in one matter, I didn't take the instructions in that, my lords. In fact, we were preparing for this matter to, my lords, my judgments also I'll be relying upon. My lords, I'll just submit, my lords, the broader outlines of the case, my lords, on which Section 22A, my lords, 1 and 2, when it was earlier introduced by amending Section 22A, my lord, since there was no policy that was evolved by the Act in itself, and certain power was given to the executive to formulate a policy as to what documents are to be registered. That excessive delegation was found fault with, my lord, the Honorable Supreme Court in state of Rajasthan's case, while dealing with the identical, the provision was in pari materia with the state amendment as then was, my lords. After the earlier amendment was struck down, my lords.
Why two synopsis? One is in the here also.
Lords?
You have given two synopsises. One is annexed here also and separately also. Is there any distinction?
There's no separate, my lords. I think
no, here synopsis filed by running index.
Yes, my lords. Page 1. Yes, that is enough, my lord. That your lordship.
Synopsis.
My lords, this is in fact, my lord, though it is elaborate, my lords, but the relevant thing your lordship can certainly refer to. But as a complete, my lord, is the complete analysis of the subject issue. My lords, when the Honorable Supreme Court remanded the matter, the virus of Section 22A as amended.
One. Oh, sorry. It's given other synopsis is by petitioner. Correct. Yes.
My lords, pursuant to the, my lords, the amendment, may I submit, my lords, the how the earlier amendment at page 3 of this compilation, which my lords, existing provision and the proposed amendment, how it have been legislated. My lords, 22(1)(a) as brought in by the state, my lords, pursuant to the judgment of the Honorable Supreme Court in 2015. What is prohibited is, my lords, the transactions in relation to the properties where, my lords, when the property belongs to the central government or the state government, or when the property is, my lords, belonging to an endowment institution or a work property, or when a property, my lords, are covered by a legislation, transfer of which is prohibited, or where the title is vested with the government. And the class E, my lords, where avowed or accrued interest in favor of the central government or the state government, as the case may be. My lords, what is sought to be achieved by this amendment is transactions in respect of the properties owned by the government and its instrumentalities, where an avowed or accrued interest is, my lord, derived by the state or the central government. What is prohibited is transaction which my lord, the private parties enter into in respect of that property, that only is prohibited from registration. My lords, the challenge, the virus of the act and the grounds, my lord, which are available generally to a litigant. My lords, on the executive, my lords, the legislative function and whether the act offends the part 3 of the constitution or any of the provision of the constitution. My lords, whether it is arbitrary, my lords, it is expanded by the Honorable Supreme Court in Shaira Banu's case, whether manifest arbitrary is there or not. These are the broad grounds on which either any act or a provision in an enactment, my lords, can be assailed. What they say, my lords? The basic contention which has been argued by the learned senior, both the senior counsels have argued that 22A, my lords, is in contradiction or in violation of section 17 and other provisions of the Registration Act. My lords, absolutely no, my lords. By mere register, the general law on the given aspect is that mere registration of any document do not, my lords, approves or validates or asserts or guarantees any title in favor of the transferee. The object of section 17 and the registration of the instrument, my lords, has been well discussed by the full bench. My lords, when certain writ petitions were decided by this honorable court, in 6 benches of this court, my lords, have decided by dealing with the provisions 22(1)(a) to E. My lords, in one of the benches of this court, having found that there is some inconsistency in the views of this court, has referred the matter to the full bench. The full bench has then, my lords, has dealt with each and every one of the provisions and finally gave certain directions. The validity or otherwise of the clauses A to E were well deliberated upon by this honorable court. My lords, nonetheless, since the Honorable Supreme Court remanded the matter to this Honorable Court to deal with the virus, my lords, on this virus which is challenged, on, my lord, the touchstone of Article 14, whether there is any arbitrariness, that is the only issue, my lords, has to be examined, because as regard the legislative competence, my lord, the state, by virtue of, my lord, it is in the concurrent list. Item 6 and 7.
So first you tell whether any presidential assent has been used, because that is.
My lord, there has since presidential assent in the act itself, my lord, the page. At page, the GO, my lord, is file 14. GO 22, my lords,
page
15, my lords. The following act of the Andhra Pradesh Legislative Assembly, which was reserved by the governor on 19th January 2007 for the consideration and assent of the president, received the assent of the president on 28th May 2007. And the said assent is hereby first published on 8th June 2007 in the Andhra Pradesh Gazette for general information. My lords, when the proposals were sent to the central government, my lord, the statements of objects and reasons are at page 1, my lords, of this compilation. Page 1N, my lords, after the synopsis. May I read, my lords? Section 22A of the Registration Act 1908 in its application to the state of Andhra Pradesh has been incorporated by Act 4 of 1999 to empower the government to notify the registration of such documents or class of documents as opposed to public policy and to reject their registration. The High Court of Andhra Pradesh in WP number so and so batch cases issued orders declaring the provisions of Section 22A of the Registration Act 1908 inserted by the registration Andhra Pradesh Amendment Act 1999 as unconstitutional and struck down the said Section 22A on the ground that the public policy is not defined precisely. Following the judgment of the Supreme Court of India in case of State of Rajasthan versus Basant Mehta, wherein Section 22 of the Registration Act 1908 in its application to the State of Rajasthan was struck down. While striking down the said provision, the Honorable Supreme Court observed as follows. The legislature of a state, however, may lay down as to which acts would be immoral, being injurious to the society. Such a legislation being substantive in nature must receive the legislative sanction specifically and not through a subordinate legislation or executive instructions. The phraseology opposed to public policy may embrace within its fold such acts which are likely to deprave, corrupt, or injurious to the public morality, and thus essentially should be a matter of legislative policy. But in order to overcome the deficiencies as observed by the Honorable High Court, keeping in view of the observation of the Supreme Court and to avoid the illegal transactions of transfer of property relating to government, religious and charitable institutions, etc., it has been decided to amend the Registration Act 1908 suitably by specifying the classes of documents prohibiting them from registration. It has also been decided to validate the notification declaring the class of documents as opposed to public policy and consequently refusal of the same for registration during the period from 1/4/1999 to the date of the commencement of the present amendment by inserting validation provision. My lords, the proposals sent at page, my lord, 8 of this compilation to the Government of India for the assent of the Honorable President, my lords. On page 9, the third para, my lords, the objective of that. In order to overcome the deficiencies as observed by the Honorable High Court, keeping in view of the observations of the Supreme Court and to avoid the illegal transaction of transfer of property relating to government, religious and charitable institutions, etc., it has been decided to amend the Registration Act 1908 suitably by specifying the classes of documents prohibiting them from registration. My lords, the draft of the proposed amendment which was sent to the, my lords, the central government, the existing provision 22A which was struck down and the proposed amendment which, my lord, as it stands now in the act has been well defined because the elaboration was not there. The Supreme Court find fault with the, my lords, the executive where, my lords, various notifications were issued. That was found fault with because unless the statute specifically says what is public policy, what you are supposed to prevent that. In that context, that earlier amendment was struck down. My lords, 22A, A to E, categorically, specifically the object that is sought to be achieved. My lords, it is the haunted objective. In fact, my lords, because several registrations were taking place in respect of these properties. Whereas as far as the purchaser is concerned, my lords, in fact, this measure helps the society wherein, my lords, if it is in the prohibitory list, the transaction itself will not, my lord, fructify into a registered instrument. The buyer, the caveat emptor principle as far as the buyers are concerned, my lords, in the interest of the buyer, in the interest of the society, in the larger interest of public, this cannot be found fault with at all in the petitioners on the ground that it offends 17. How does it affect 17, my lords? Nothing has been stated except saying that 17, when the document is presented, states that a document shall be registered. My lord, 17, what it describes is what are documents compulsorily registerable, that it says. And whenever a document is presented, my lord, under certain circumstances, the provisions of Registration Act do empower, entitle the registrar to refuse registration. This is these are the instances under A to E, where the registrar, by, my lords, if it is informed by the concerned collector, my lords, the vendor or the so-called person having an interest claiming to be a title holder cannot be said to be, my lords, aggrieved by this action of notifying the registrar that don't entertain any registration. This is, after all, my lord, in the legitimate expectation of the citizen. How can he expect that a government property still is entitled to register it? My lords, that there is no legal or my lords, the argument cannot be countenanced at all in the matter of these so-called petitioners who challenge that my right is infringed. I cannot be dealing with the property because you have put my property in the prohibitory list. This is, my lord, there is an about interest. If you have any grievance, if it is government property, I am putting it in the prohibitory list. This can't be said at all, my lords, by the person who stakes a claim in such property that no, this deprives my right of dealing with my property. It is not his property we are putting in the prohibitory list. My lords, my lords, Article 254, because since it has an approval of the Honorable President, there can't be any, my lords, ground at all. It offends the other provisions of the Act. May I submit, my lords? I'll take your lordships to the judgment, my lord, on the broader principles.
You are referring to full bench.
My lord, full bench. Exhaustively, how it has dealt with, I'll take your lordships to the relevant paragraphs. And the full bench judgment, my lord, your lordship will find at page 46 of this compilation, my lord. 48. What is the objective of the Registration Act? My lord, the full bench has dealt with while referring to the judgment of the Honorable Supreme Court in Suraj Lamb's case. Para 47 and 48. My lord, I will read the relevant paragraphs as to how the full bench of this Honorable Court has dealt with the provisions elaborately. Though, my lord, your lordship will be certainly dealing with the virus on the ground of arbitrariness or on the ground of principles of natural justice. But the full bench has also considered those things, my lord. Yet your lordship may have to, in the light of the Honorable Supreme Court's direction having been remanded the matter, your lordship can independently deal with, my lords, with regard to the virus and the touchstone of Article 14. My lords, 47 and I will read, my lords, the relevant paragraphs in my lord, 47, 48, 99, 120, may I say, my lords, 47, 99, whereas 126 to 138 and para 157. Para 47. The Registration Act was enacted to consolidate the enactments relating to registration of documents. Prior to enactment of the said Act, the provisions relating to registration of documents were scattered in different enactments. The Registration Act was enacted in terms of Entry 18, List 2 and Entry 6, List 3 of 7th Schedule of the Constitution of India. It mainly deals with the necessity of getting a document registered in India so as to make them valid, and even if they are executed outside India, to provide for registration thereof after their first arrival in India. State of Rajasthan, my lord, Basantanath is referred here. Intention of the legislation was to provide orderliness, discipline and public notice in regard to the transactions relating to immovable property and protection from fraud and forgery of documents of transfer. This is achieved by requiring compulsory registration of certain type of documents and providing for consequences of non-registration. My lord, the amendment is in furtherance of this objective, which has been well deliberated by the Honorable Supreme Court even in Basantanath's case. There are 48, my lord. The Supreme Court in Suraj Lamp and Industries Private Limited versus State of Haryana had an occasion to deal with few provisions of the Registration Act and of other relevant enactments. What the Supreme Court observed in para 18 is relevant for our purpose to understand importance of registration of documents, which reads thus, para 18 of Suraj Lamp, my lord. Registration provides safety and security to transactions relating to immovable property, even if the document is lost or destroyed. It gives publicity and public exposure to the documents, thereby preventing forgeries and frauds in regard to transactions and execution of documents. Registration provides information to people who may deal with a property as to the nature and extent of the rights which persons may have affecting that property. In other words, it enables people to find out whether any particular property with which they are concerned has been subjected to any legal obligation or liability, and who is or are the persons presently having right, title and interest in the property. It gives a solemnity of relevancy by recording them, where people may see the record and inquire and ascertain what the particulars are, and as far as land is concerned, what obligations exist with regard to them. It ensures that every person dealing with immovable property can rely with the confidence upon the statements contained in the registers maintained under the said Act as a full and complete account of all transactions, by which the title of the property may be effected and secure extracts copies duly certified. My lords, this explanation by the Honorable Supreme Court strengthen the object that is sought to be achieved by this amendment, my lord. This is never can be said to be arbitrary or, my lords, in contradiction with any of the provisions of the Registration Act. After all, my lords, mere registration of a document doesn't itself, my lord, can be said to validate the title. Therefore, their argument that I will be deprived of my right. You will not be deprived of your right in respect of the property of the government, or I work for an endowment. There are several mischiefs that those were happening. But in fact, in the country, almost all states have enacted the identical provision. The earlier provision which was struck down, my lord, where the states have, my lord, having come to know of the ratio laid down by the Honorable Supreme Court, they have elaborated by the statute itself. They can still, the citizen cannot be permitted to say that no, I will deal with your property, the state's property, the public property. Well, the next paragraph of this judgment, 99 minutes, page 86, my lords. Yes, while considering other provisions, my lord, 99 at page 86. Before we consider clause E, clause E deals with, my lord, where the state acquires the right and interest, about or accrued interest. That's what they deal with, my lord. In two instances, at the instance of the central government and the state government, 2 gazette notifications were issued so far. Before we consider 99, my lords, before we consider clause E, we would also like to consider common questions concerning clause A to D of subsection 1 of section 22A. The first incidental question raised is whether either the concerned competent officers of various departments of the governments or registering authorities have any scope for playing any mischief or unbridled powers while preparing and sending the list of prohibited properties to the registering authorities or while registering the documents. And who is the competent appropriate authority which has to forward a list of prohibited properties covered by clauses A to D of subsection 1 of section 22A. My lord, these issues have been well deliberated. In the subsequent paragraphs, my lords, each and every provision has been well deliberated. I am not reading the, my lords, to save the time, precious time of this honorable court. My lord, paragraph 126 to 138, my lords, deal with the principles of natural justice. From page 1 or 2. Taking up the contention that unless prohibited properties are notified as contemplated under clause E read with subsection 2, it is not possible for the citizens to know whether or not registration of a particular property is prohibited, and that principles of natural justice mandate that such notification is necessary even in cases of classes of documents falling within the ambit of provisions of clauses B and C. We may state that there is no acceptable merit in this contention for the reason that the government department headed by the Inspector General of Registration and Stamps is maintaining a website with the necessary and complete information, wherein the list of prohibited properties under clauses A to D of subsection 1 of section 22 are made available. Placing such information on website is also provided for in the guidelines. Further, whenever any citizen would approach the registrar concerned with an application to find out whether any property is included in such list, the registrars concerned are not only expected but must provide information as may be required by the parties concerned so as to enable them to proceed to enter into transaction of sale, conveyance, gift, etc., or to take appropriate steps for its deletion from the list. Having browsed and verified the website of the government, namely IGRS so and so, of the state of Andhra Pradesh and registration, Telangana so and so, of the state of Telangana, we find that the respective websites of the government provide all and the necessary information, and therefore it cannot be said that the citizens have no access to the list contained prohibited properties available with the registrar's consent, and hence there is sufficient compliance of the principles of natural justice. 127, my lord. Next, we would like to consider whether the principles of natural justice can be read into subsection 2 of section 22A to mean that while incorporating or mentioning any property covered by clause E of subsection 1, in the notification contemplated by subsection 2, affording opportunity of being heard to a person who claims right and interest in such property. Mr. So-and-so lends senior counsel in support of his contention that the principles of natural justice need not be read into subsection 2 of section 22 of the Registration Act, relied upon by the following judgments, so-and-so. My lords, we can go to para 133, my lords. 133. Having regard to the principles called out in the judgments of the Supreme Court, in our firm and considered opinion, subsection 2 of section 22A does not contemplate such hearing, and it is clear from the schema of section 22A, in particular subsection 4 thereof. Subsection 4 provides for an effective mechanism remedy to a person aggrieved by the notification prohibiting registration of a document to either comply to the state government or to make an application to denotify, either in full or in part, the notification issued under subsection 2. When the government is satisfied that a property is wrongly notified, it may either suo motu or on an application by any person denotify either in full or in part the notification issued under subsection 2. This clearly indicates that if a property is incorporated or mentioned in the notification, and if any person is aggrieved thereby, he has a remedy to approach the state government challenging inclusion of his property. And if he satisfies the concerned authority of the state government, it may proceed to denotify either in full or in part the notification issued under subsection 2. So far as subsection 3 of section 22A is concerned, it provides that notwithstanding anything contained in the Registration Act, the registering officer has power to refuse registration of documents to which a notification is issued under clause E of subsection 1. Thus, it is clear that while publishing a notification, hearing is not contemplated under subsection 2 of section 22A. Since subsection 4 of section 22A provides a remedy to an aggrieved party to approach the state government for deletion of his property from the notification, it is needless to mention that if an application as contemplated by subsection 4 of section 22A is made by any person, the concerned authority is expected to grant an opportunity of being heard and also to produce the materials, documents in support of his claim, and that the concerned authority shall deal with the application and the prayer made therein in the light of the material, documents produced by him, and to pass a speaking order either rejecting the application or allowing the same by deleting his property from the notification. Yes. Well, that's from paragraph 136 to 138. Well, it clarifies and strengthens the objective of my lords 22A1E. Yes. My lords, para 138, I'll read, my lords, because the allegation that there can be a possible arbitrary exercise of the power. How the full bench has dealt with that issue also, my lord. Para 138. Therefore, this notification which provides guidelines to the district collectors for furnishing reasons and description of property prohibited from registration takes adequate care to prevent abuse and misuse of Clause E of subsection 22A1 of the Registration Act. Hence, the apprehensions expressed before us are misplaced and do not need countenance. Further, the notification either in part or full always subject to the judicial review. Therefore, in view of the adequate safety measures provided under section 22A, in particular subsection 2 and 4, thereof, insofar as clause E of subsection 1 is concerned and the guidelines insofar as A to D are concerned, in our opinion, of any such misuse or abuse is subject to review by the government and also judicial review, and therefore there is no possibility for any misuse or abuse, and any such acts of misuse and or abuse are amenable for correction. My lords, the full bench. What is the other para? Yes. 157. The last para from the judgment, my lords. The legal recourses are, my lords, to ventilate any grievance, how that has been dealt with by the full bench of this honorable court at page 112, para 157 of the judgment. Further, as noticed earlier, the state government is empowered either suo motu or an application to consider the grievances against inclusion of any property in the prohibitory list under section 22A of the Registration Act, and is also empowered to denotify either in full or in part the notification issued under subsection 2. In our opinion, the redressal mechanism is available only with respect to notifications published relating to the properties falling under clause E of section 22A. Hence, any grievance of the parties with reference to the properties covered by clauses A to D will have to be questioned by the aggrieved parties only by appropriate proceedings before a competent court, and the adjudication by such court would be final. Further, so far as notified properties falling under clause E are concerned, the redressal mechanism under subsection 4 of section 22A would be able to effectively address the grievance provided the mechanism thereunder is effective, expeditious, fair and judicious. Thus, in order to make effective redressal mechanism, we deem it appropriate to direct the respective governments of both the states to constitute a committee or establish a forum within time frame may be comprising of Principal Secretary of Revenue, Director of Survey and Land Records, and a retired judicial officer of the rank of a district judge, who shall meet periodically to consider the grievances of the persons affected by the notifications. The committee shall be empowered to examine relevant records and then pass a reasoned order either accepting or rejecting the grievances by either confirming, deleting, modifying any such property from the notified list of properties. In our view, such orders passed by the committee shall be binding on the state as well as on the aggrieved persons, and in the event of any of them being aggrieved thereby, they shall have to approach a competent court of law for redressal of their grievance. My lords, this is the complete analysis of the provisions where all, my lords, are the arguments as advanced before this honorable court. But in fact, my lords, have been dealt with by the full bench. My lords, coming to the basic legal aspect as to the question, how it is, my lords, as far as, my lord, the virus is concerned, my lord, the state inheres. Yes.
This application is very prior to the amendment. Which it is very this is convinced.
They let go for this one.
Case. No, there are some cases which at least the existing document. We'll ask him. We appear. Who is appearing for petitioners? See, in this, in the petition, what is under challenge is prior to the amendment. What we are thinking is that is subsequent to the substituting section 22A1, prayer has to be amended. What has been challenged is earlier to the amendment.
I matter is 42, I have with that I challenge.
So you have made the amendment.
Subsequent case. Your lordship can take judicial notice of the fact that what is impugned in the batch of writ petitions. My lords, the law on the aspect when act is challenged, my lords, I take my lords 5 judgments of I have compiled and given it. It will be covered a little bit payment. I gave it in the folders, my lords. Yes, ma'am. 2003 5 SCC 239, my lords, the relevant paragraph is paragraph 4. Paragraph 4. In examining the constitutional validity of the impugned provisions of a statute, it will be useful to bear in mind the following well settled proposals. 2003 5 SCC. The following well settled propositions. If a legislation is found to lack in legislative competence or it is found to be in contravention of any of the part 3 or any other provisions of the constitution, the impugned legislation cannot escape the vice of unconstitutionality. A challenge to any statutory provision on the ground of the classification being discriminatory and violative of Article 14 of the Constitution can be successfully met on the principle of reasonableness, classification having nexus to the object of the act sought to be achieved. However, the legislature enjoys a greater latitude for classification in the field of taxation. No legislation can be declared to be illegal, much less unconstitutional, on the ground of being unreasonable or harsh on the anvil of Article 14 of the Constitution, except, of course, when it fails to clear the test of arbitrariness and discrimination, which would render it violative of Article 14. My lords, the broader principles, my lords, nothing has been argued, my lords, at all as to how their rights are affected by virtue of this amendment. How the provisions are in contradiction. The amended provision is in, my lord, in violation of the other provisions. Absolutely nothing has been, my lord, argued, rather except saying that no, we are entitled to register the document when it is presented. The registrar ipso facto is liable to register. That is not the purport of Registration Act at all. My lords, 2010 SCC 6 SCC 499, para 15, my lords. It is well settled that a statute can be invalidated or held unconstitutional on limited grounds. Para 15, my lords. On the ground of the incompetence of the legislature which enacts it, and on the ground that it breaches or violates any of the fundamental rights or the other constitutional rights, and no other grounds. My lord, the broader principles, my lords, till that the triple talaqs case, where, my lords, manifest arbitrariness is also, my lord, introduced.
The other one is 2008 volume 5 SCC 580. Which
yes,
para?
There are 11, 19 and 20, my lords. 11 dealt with the provision of, my lord, this is concerning the Foreign Exchange Regulation Act, my lords. The one provision, my lords, there are 11. There are section 18 of the Fair Act, my lords, subsection 3 of section 18. On the next page, my lords, just above para 12.
where in relation to any goods to which a notification under class A of subsection 1 applies, the prescribed period has expired and payment therefore has not been made as aforesaid. It shall be presumed unless the contrary is proved by the person who has sold or is entitled to sell the goods or to procure the sale thereof, that such person has not taken all reasonable steps to receive or recover the payment for the goods as aforesaid, and shall accordingly be presumed to have contravened the provisions of subsection 2. This is, my lords, dealt with in para 19 and 20, the challenge of that. A legal provision does not become unconstitutional only because it provides for a reverse burden. The question as regards burden of proof is procedural in nature. There are 20 minutes. The presumption raised against the trader is a rebuttable one. Reverse burden has also statutory presumption can be raised in several statutes, as for example the Negotiable Instruments Act, the Prevention of Corruption Act, TADA, etc. Presumption is raised only when certain foundational facts are established by the prosecution. The accused in such an event would be entitled to show that he has not violated the provisions of the Act. In a case of this nature, particularly when an appeal against the order of the tribunal is pending, we do not think that the appellants are entitled to take the benefit thereof at this stage. Such contention must be raised before the criminal court. My lords, A to D, the full bench has analyzed, having analyzed the provisions A to D. My lords, if the person is aggrieved, he has to approach the civil court. As far as class E is concerned, my lords, there is a mechanism devised, and this honorable court directed to constitute a committee, and their decision.
No, but there is no, it's not a case of any statutory presumption, right?
Well, here, what, my lords, the question which was, my lord, the provision which was challenged as to, my lord, the presumption as to the criminality in the acts of the accused. When that such an act was, the provision was challenged. That cannot be, the Supreme Court said that you cannot seek to strike down merely because it presumes against you. That's what. Well, here, their apprehension is that once I notify, that it is final. This can't be. That is the argument, my lord, they wanted to place, in fact. Therefore, the mechanism is devised. They have every right to go before the civil court. They can't, my lord, challenge this allowed provision on the ground that my right is affected, my right is deprived. Yes. My lord, sir, the Constitution Bench judgment 2011-9 SCC There are 84 and 85. My lord, the view of the Honorable Supreme Court, in fact, in this judgment is affirmed in Aadhar's case, my lord. In fact, I prepared a note, I will read to your lordship that. There are 84, 85. Yes. And next, my lord, there are 180, 187, 181, 205 and 217. There are 84 and 85 minutes. I'll just take your lordships to. There are 84, my lords. We also find no force in the contention that opportunity of hearing is a precondition for exercising under section 110 of the Act. No such requirement has been provided under section 107 or section 110. When the exemption was granted to Roericks, no hearing was afforded. So also when
Mr. Advocate General, there is one thing, like if some, even if it is assumed, perhaps this could be your argument, we don't know, that full bench gives issues guidelines to regulate the discretion conferred so far as this thing, declaration of prohibited list or whatever is concerned.
Yes.
The full bench has issued guidelines, right, to regulate your discretion.
Yes, my lord.
And merely because perhaps a provision can be misused, it cannot be struck down.
Correct, my lords. And my lords, the law on the given aspect, the general law, my lords, enunciated by the Honorable Supreme Court. There is no, my lords, there is no arbitrariness at all in this, my lords, in the amendment. And the objective, my lords, what is sought to be achieved is relevant. Transactions concerning these properties, state government, central government, work and other categories, my lords, which have been clearly dealt with now, which was my lord, lacking on in the earlier amendment.
We'll continue.
Yes.
That's the guideline,
Item number 15.
I'm appearing for the work code, in item 41 and 42. Just to answer your lordship's question with regard to the full bench issue, my lord, not only the guidelines, but they've also evolved a grievance mechanism, and my lords, which may not take so much time, but deal with emergent issues with regard to facts in a more competent way, which normal courts may not do. Now, the whole purpose is that grievance redressal mechanism will have all the facts on it for it to deal it in a time efficient way. So that I think that's the whole purpose of the full bench.
We'll hear you also. We didn't know. Yeah, last time you were not there.
Well, I was engaged by them in the 11th hour.
Yes.
I may ask for 1 day's time tomorrow, my lord, sir.
What 1 day's time?
Because they had engaged me at the 11th hour.
Let's see. Let's first hear the Advocate General.
My lord, item number 15 and 16, it was passed over in the morning, your lordship.
Tomorrow.
There's an interim order also in place, my lord. We were under the impression that it will be called at 2:30.
Well, don't be under any impression, madam.
I apologize, my lord.
This thing, every court is different. We have been taking up immediately. We don't want to put a premium on conduct of a counsel and not appearing in first round and giving him facility. It is, then you are under an obligation to appear as and when it is called. The moment
I
we don't-
apologize, my lord. Your lordship may take it up.
Tomorrow it's coming up.
The
We have
order will
said
be
none for
extended.
petition tomorrow, no? Interim order shall continue. You write that tomorrow it has listed. Yes.
Obliged.
You have 1 hour to prepare, Mr. Reddy.
That may be
1 hour. Hey, Pathward case, how can you?
In fact, I was engaged late, my lord, that's all. Otherwise, I would have been ready.
Before he began, you should have said no. Ready?
And endeavor to.
Yes. All right. Acha, lunch. Lunch motion one.
My lords.
I beg to appear in this matter. Well, this intra-court appeal is filed by the third respondent in the writ petition. The first respondent in the appeal is the writ petitioner. The order passed by the learned single judge is at page number 9, Malik. The prayer made in the writ petition is, or interlocutory application is, because this is passed on year number 1 of 23 in
It's
WP
listed
number.
today. What happened?
Well, the election program was finalized.
No. This one thing with this interim stay has spread post on 9/10. So we are asking what happened, whether it has reached.
It has not
No,
reached.
it has not been listed. It has
No,
not
it is
reached.
listed at 97th item today.
Item number 97, Millet. And election polling starts tomorrow and it continues on 12. This society, Millet, South Central Railway Employees Cooperative Credit Society, which is not having any aid or control of any state government. And it's a multi-state cooperative society operating in 5 states, Telangana, Andhra
No,
Pradesh.
but the matter is fixed today before single judge, right?
Now, the order was passed on Friday, Millet. It is posted today. And we are not given notices also. Now, Millet, the entire arrangements for the election, including the polling station.
No, what we are, Mr. Senior Counsel, is still, I mean, you can address the single judge on this issue. And let's see, we will take up the matter little later after at 4 o'clock.
The polling dates are 10th and 12th, Millet. After the
correct.
polling dates are over, Millet.
We are not saying that we will not hear it today. What we are saying is the matter is posted on 10th. You mention the matter before learned single judge, argue it, and then tell us what has happened. We will take it up before this thing rising today itself, if necessary.
I will mention
Yes.
and come back to it.
Yes, we will take it up before we this thing
Very well.
rise for the day. You keep it, madam, pass over round.
That's right. As a matter of fact, he was heard on Friday. It's not as if he was not heard on Friday.
No. So, today it is directed to be listed because please mention the matter.
Very well. I appreciate.
So it's already listed today.
Yes, my lord.
Let's see. We will take it up, Mr. If need be, we will take it up.
Which is covered matter, my lord.
Huh?
So covered matter, my lord. Similar order in 765/2023, my lord. Page number 23 to 22, my lord. Page number 23 to 27, my lord. Similar order.
23. Yes.
Item 2.
23. Huh?
22.
Page certified copy today disposed of.
Similar order.
23.
No, my lord.
Certified
26 to
copy
30.
today. Huh?
26 to 30, page number.
Also, you tell Mr. That's what we are asking. 26 to 30. Certified copy.
Problems, my lord.
Page number 22, my lord.
22. Certified copy.
Page number 20, my lord.
20. Disposed. Now you keep, madam, remind us that matter when, right? That rate passover matter. Now whenever if need be. Yes.
Yes. My lord, sir. 2011-9 SCC, Constitution Bench judgment, my lord, sir. The challenge in this, my lord, sir.
2000?
2011-9 SCC 1, my lord.
You are.
There are 25, my lord, the challenge of challenge to a provision.
It should have been given along with an index, Mr. Instead of this loose thing.
My lords, these
Index
were.
and paragraph numbers.
I'll give that.
Yes, madam, you should have done that work instead of simply taking a printout.
She has done it, my lord. In fact, the
So
extensive
that
research she
she,
has done.
that's what we are telling her.
Yes.
She should have also prepared an index writing paragraph numbers.
Will do.
Yes.
Yes.
Para
There are 25, my lord, sir. The challenge
waiting
to
for you read.
yes, my lord. But my lord, sir, to go to the relevant findings, my lord, sir, the challenge made in this section, which are similar to this type of challenge made in the first subject to petitions. What was challenged in this is, my lord, section 110 of the Karnataka Land Reforms Act 1961. In para 25, it is referred to, my lord, sir. Then para 54, we can go to para 54. Section 107 we have already indicated is made subject to section 110, which reads as follows. By 110, certain lands to be not exempt from certain provisions. The state government may, by notification, direct that any land referred to in section 107 and 108 shall not be exempt from such of the provisions of this act, from which they have been exempted under the said sections. My lords, this was challenged on the ground that there is a possible, my lord, abuse. Well, the discussions, there are 84 and 85. Whether, my lords, the power to denotify the property which is vested with the authority, an opportunity was sought to be given. That was the challenge made in this. Para 84 and 85, my lord. We also find no force in the contention that opportunity of hearing. Paragraph 84.
One.
Yes, page 34, internal page 34.
Yes.
We also find no force in the contention that opportunity of hearing is a precondition for exercising powers under section 110 of the Act. No such requirement has been provided under section 107 or section 110. When the exemption was granted to the Roerichs, no hearing was afforded. So also when the exemption was withdrawn by the delegatee. Para 85. It is trite law that exemption cannot be claimed as a matter of right. So also its withdrawal, especially when the same is done through a legislative action. Delegated legislation, which is a legislation in character, cannot be questioned on the ground of violation of the principles of natural justice, especially in the absence of any such statutory requirement. Legislature or its delegate is also not legally obliged to give any reasons for its action while discharging its legislative functions. My lord, the next paragraph is 180 and 181, page 53. Public purpose, my lords. It's in relation to 300 ml. Deprivation of property within the meaning of Article 300A, generally speaking, must take place for public purpose or public interest. The concept of eminent domain, which applies when a person is deprived of his property, postulates that the purpose must be primarily public and not primarily of private interest and merely incidentally beneficial to the public. Any law which deprives a person of his private property for private interest will be unlawful and unfair and undermine the rule of law and can be subjected to judicial review. But the question as to whether the purpose is primarily public or private has to be decided by the legislature, which of course should be made known. The concept of public purpose has been given fairly expansive meaning, which has to be justified upon the purpose and object of the statute and the policy of the legislation. Public purpose is therefore a condition precedent for invoking Article 300A. My lords, para 205 and 217 are the relevant paragraphs from this judgment, my lords. There are 205. page 58. Plea of unreasonableness, arbitrariness, proportionality, etc. always raises an element of subjectivity on which a court cannot strike down a statute or a statutory provision, especially when the right to property is no more a fundamental right. Otherwise, the court will be substituting its wisdom to that of the legislature, which is impermissible in our constitutional democracy. My lords, the last paragraph from the judgment 217, my lords, at page 61. The rule of law as a principle contains no explicit substantive component like eminent domain, but has many shades and colors. Violation of principles of natural justice may undermine the rule of law, resulting in arbitrariness, unreasonableness, etc. But such violations may not undermine the rule of law so as to invalidate a statute. Violation must be of such a serious nature which undermines the very basic structure of our constitution and our democratic principles. But once the court finds a statute undermines the rule of law which has the status of a constitutional principle, in the basic structure, the above grounds are also available and not vice versa. Any law which in the opinion of the court is not just, fair and reasonable is not a ground to strike down a statute, because such an approach would always be subjective, not the will of the people, because there is always a presumption of constitutionality for a statute. My lords, 2010 10 SCC 744, my lords, the three judges bench decision, Competition Commission of India versus Steel Authority. This is with regard to the, my lords, principles of natural justice, paragraphs 67, 7, my lords, 80 and 85 are sufficient. 80, 85 and 86. '85 and 86, my lords. Paragraph 85 and 86 at page 782 of this judgment. Paragraph 85, where this court has dealt with the matters relating to complaint of violation of principles of natural justice. Right. It has always kept in mind the extent to which such principles should apply. The application, therefore, would depend upon the nature of the duty to be performed by the authority under the statute. Decision in this regard is a fact panacea to the rival contentions which may be raised by the parties in a given case. Reference can be made to the judgment of this court in Canara Bank versus so and so. We may also notice that the scope of duty cast upon the authority or a body and the nature of the functions to be performed cannot be rendered nugatory by imposition of unnecessary directions or impediments, which are not postulated in the plain language of the section itself. Natural justice is a term which may have different connotation and dimensions depending upon the facts of the case, while keeping in view the provisions of the law applicable. It is not a codified concept but are well-defined principles enunciated by the courts. Every quasi-judicial order would require the authority concerned to act in conformity with these principles, as well as ensure that the indicated legislative object is achieved. Exercise of power should be fair and free from arbitrariness. My lords, the principle laid in this judgment also, my lord, to cover to some extent to answer the challenge made to the section 22A. There is no mechanism that is required, my lords, before the property is notified to the sub-registrar by the district collector under A to D and the government under clause E, my lords. My lords, the judgment, the constitution which judgment, my lords, this KT plantation, in fact, my lords,
So one thing, Mr. We wanted to know, when was the matter remitted by Supreme Court? What was challenged and what was the
my lords, the full bench judgment was challenged before the Supreme Court.
Achha.
In fact, in the note I have detailed every material, my lord.
So
the synopsis.
So where is the order of Supreme Court? Remand?
That is in Srinivasam case, my lord, sir. In writ petition 21187, 2021, page 41 onwards, it is in fact cited decision. On the directions, my lord, issued by this honorable court. Page 62 of this writ petition, my lords, para 5 of the judgment rendered by the Supreme Court. From para 5, my lords. After issuing the above directions, the matters have been remitted to the bench concerned for considering other issues, including the validity of section 22A of the Act. The learned counsel for the state points out that the main issues pending before the High Court is the virus of section 22A of the Act. All the contentions now sought to be
So
raised.
this is in pursuance, these petitions have come up again in pursuance of order of remand.
Yes, my lords, yes. The last paragraph of the judgment. Para 8. The Land Senior Council has pointed out that the same mechanism for redressal under 22A may be made applicable as far as the grievance in respect of 22(1)(a) to D is concerned. It is pointed out that even in respect of the orders which have otherwise become final, they would be relegated to the same authority and will be subject to further revision, appeal, etc. This is also a matter to be considered by the High Court when the writ petitions are finally heard. Therefore, we permit the parties to raise this contention also before the bench concerned while considering the virus of the section. In order to reach a workable solution, the court may consider the issue on its own merit and the impugned order shall not stand in that way. Yes. My lords, as far as the virus is concerned, your lordship may have to formulate questions, my lords, because as far as the legislative competency is concerned, my lords, the assent of the president since has been taken. My lords, the so-called argument made, my lord, that it is inconsistent or in contravention, repugnancy, my lord, that doesn't arise at all. And the state inheres the competence and my lords, the law which is enacted from the objective that is sought to be achieved, my lords, can't be found fault with. And the earlier amendment, which was impugned, my lords, in the given context, the striking down of that provision, my lord, that is justified. But as far as, my lord, in terms of the very judgment rendered where the state was left with the option of making out a clear law, where the power, the policy itself contained in the very legislation, which has in fact has been carried out, my lords, by way of a detailed amendment 22A, what falls under 22A 1 to E. Since they have been clearly delineated, since it is a legislative function, legislature itself prescribes the prohibition. My lords, the principles of natural justice, my lords, that fails into insignificance for the reason.
I don't think it has been argued on behalf.
Yes, my lord.
No, not. Yes.
Therefore,
basically, these twofold submissions that this thing 254 bad because inconsistent with the central legislation and then arbitrary.
254, in fact, Mr. Madan Rao said, my lord, he has fairly agreed. My friend.
Presidential assent is there, right? They can't.
And the proposals in the proposal itself, what was prohibited, my lord, the transactions were prohibited, transactions concerning, and mechanism, my lords, this honorable court has well appreciated. A to D, my lords, are the appropriate forum, the civil court or the work tribunal, they are competent to deal with the rights which may be canvassed by the aggrieved person. And E is concerned, my lord, the mechanism itself is devised under a very amended provision 22(4). My lords, the challenge is, my lords, cannot be countenanced on the grounds which have been pleaded and argued. And the act about purpose, my lords, can't be defeated by such a challenge. There is no legal challenge to this provision. I pray this honorable court to dismiss all these writ petitions. I'm obliged, my lords.
I'm appearing because of the state work code, my lord, with item 41 and 42. My lords, and my arguments, my lords, will be in addition to the honorable state, my lords, state's arguments. My lords, I just wanted to focus on two aspects, my lords, of this case, my lords, which the full bench has referred to. Those are, my lords, I wanted to focus on the interpretation of 22 cap A, my lords, which begins from paragraph 60 onwards of the full bench decision. The manner in which 22 cap A ought to be interpreted and thereby falling within the scope of constitutionality, and, my lords, the object and reasons of bringing about 22 cap A, which was otherwise missing in the earlier 22 cap A. So the earlier 22 cap A was set aside on the ground that the object was not clear. The new 22 cap A has taken care of the object and reasons issue, and, my lords, and therefore falls within the scope of constitutionality. Para 48, my lords, if your lordship were to see for a moment.
Full bench.
Full bench, yes, ma'am. Para 48, my lords, they clearly show what was there in the old 22 cap A, why it was struck down, and how the new 22 cap A, my lords, has dealt with that lacuna. My lords, may I submit 2 copies, or my lords will? Yes, lordships are.
We have.
My lords, I'm obliged. Para 48, my lords were to see.
Suraj lamp.
My lords, para 48. So the internal page 268, my lords.
Yes.
Para 48. My lords, it would be, may I read, my lords? It would be relevant to know the background against which the old section 22 cap A was substituted by Act 19 of 2007.
49. It's in our this thing, it's para 49.
Yes, okay.
SEC.
Achha.
SEC.
SEC. Oh, I actually have 2 copies of my own, my lords. If my lord, may I give those for sake of clarity?
ALD.
This is from the ALD edition. Indulo. Yes. I'll just read, my lords. My lords were to go to para 48, internal page 268, my lords.
Yes.
Merit. It would be also be relevant to know the background against which the old section 22 cap A was substituted by Act 19 of 2007. The old section 22 cap A reads thus: 22 cap A documents. This was the old one which was documents registration of which is opposed to public policy. Please notice, my lord. The state government may, by notification in the official gazette, declare that the registration of any document or class of documents is opposed to public policy. No enumeration is made of those documents as it is done now.
Please see, notwithstanding anything contained in this act, the registering officer shall refuse to register any document to which a notification issued under subsection 1 is applicable. The old section 22 cap A, as it stood prior to its substitution by Act 19 of 2007, was struck down by this court in WP 14099 of 3 and batch following the judgment of the Supreme Court in Basant Nahata case, wherein section 22 cap A of the Registration Act in the application to the state of Rajasthan was struck down. We are making reference to this old section only to bring on record the background against which the new section 22 cap A was introduced in the place of the old section 22 cap A by Act 19 of 7, made clear that the constitutionality of the new section 22 cap A of Registration Act is not the subject matter of the present reference. The old section 22 cap A in its application to the erstwhile state of AP had been incorporated by Act 4 of 99 to empower the government to notify registration of such documents or the class of documents as opposed to public policy and to reject the registration as stated earlier. It was struck down. Lordship may please notice, it was struck down on the ground that the public policy was not defined precisely. We have therefore also looked into the object and reasons set out in the statement of object and reasons for substitution of by Act 19 of 2007. The relevant portion of the statement of object and reasons reads thus: in order to overcome the deficiencies as observed by the Honorable High Court, keeping in view of the observations of the Supreme Court and to avoid the illegal transactions of transfer of property relating to government, religious and charitable institutions, etc., it has been decided to amend the Registration Act suitably, Lordship may please notice, by specifying the classes of documents prohibiting them from registration. This was otherwise absent in the earlier unamended section. It has also been decided to validate the notification declaring a class of documents as opposed to public policy and consequently refusal of the same for registration during the period from 1/4/99 to the date of commencement of the present amendment by inserting a validation provision. It is well said. Now, madam, the object of statement of object and reasons makes it clear that the lacuna, perhaps of excessiveness, which was otherwise there in the 22 cap A unamended provision of making it available to the government any document and to the registrar any, that has been taken care of by specifying what those documents are. Lordship may please see. It is not well settled that the statement of objects and reasons play a very significant role in understanding the legislative intent. In state of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat, the Supreme Court, while considering the significance and role of the statement of objects and reasons, not only in understanding the intent of the legislature, but in interpreting the provisions of an enactment in para 69 observed thus: reference to the statement of objects and reasons is permissible for understanding the background, antecedent state of affairs in relation to the statute and the evil which the statute has sought to remedy. This evil, lordships have seen what it was, if I may use that term, and what that this new amendment has sought to remedy. So lordship may please see by enumerating those documents that excessiveness evil has been taken care of. In state of WP West Bengal versus Subodh Gopal Bose, the Constitution bench was testing the constitutional validity of the legislation impugned therein. Statement of objects and reasons was used by S.R. Das J for ascertaining the conditions prevalent at that time, which led to the introduction of the bill and the extent and urgency of the evil which was sought to be remedied, in addition to testing the reasonableness of the restrictions imposed by the impugned provision. In his opinion, it was indeed very unfortunate that the statement of object and reasons was not placed before the High Court, which would have assisted the High Court in arriving at the right conclusion as to the reasonableness of the restriction imposed. Lordships are now seeing the objects and reasons. That issue is no longer here. The State of West Bengal versus Union of India approved the use of statement of objects and reasons for the purpose of understanding the background and the antecedent state of affairs leading up to the legislation. Thus, it is clear that the facts stated in the statement of object and reasons appended to any legislation are evidence of the legislative intent. They indicate the thought process of the elected representatives of the people and their cognizance of the prevalent state of affairs, which, my lord, the learned AG was trying to submit before your lordship. What are the problems which the state is encountering and how it seeks to deal with those illegal actions with this provision, impelling them to enact the law. These, as observed in Mirzapur Moti Qureshi Kasab Jamat's case, constitute important factors which, amongst others, will be taken into consideration by the court in judging the reasonableness of any restriction imposed on the fundamental rights of individuals. The court would begin with a presumption of the reasonability of the restriction. This has always, your lordship, more so when the facts stated in the statement of objects and reasons and the preamble are taken to be correct and they justify the enactment of law for the purpose sought to be achieved. Well, these two things lordships have always applied. Well, the reasonableness of a statute is presumed, and what their lordships are stating is when the object and reasons are placed before your lordships, the reasonableness becomes all the more apparent if those objects and reasons are seeking to remedy the evil which they seek to take care of. Now, the earlier enactment, lordship may see by looking at these paragraphs, was one of the evil of excessiveness, perhaps excessive legislation. That has been taken care of by the new amendment. Now, after this, my lords, lordship may see para 60 for a moment with regard to how their lordships have interpreted 22 cap A. 22 cap A. Para 60 for a moment, page 272 internal. May I read, man? Before we deal with each clause and subsection of section 22 cap A, plus I'm endeavoring to do this because statutory interpretation may be particularly essential in this examination, because, my lord, once your lordship sees objects and reasons, your lordship may also see what kind of an interpretation we have to place for 22 cap A. Then the reasonableness or otherwise arbitrariness, as the petitioners are stating, may become apparent. That the full bench has taken great pains at doing. Before we deal with each clause and subsection of section 22 cap A, in the light of the submissions made by, it would be necessary to bear in mind the settled principles of interpretation. It is well settled that courts must proceed on the assumption that the legislature did not make a mistake and that it did what it intended to do. Objects perhaps are perhaps in that. The court must, as far as possible, adopt a construction which will carry out the obvious intention of the legislature. Undoubtedly, if there is a defect or omission in the words used by the legislature, the court would not go to its aid to correct or make up the deficiency. The court could not add the words to a statute or read the words into it which are not there, especially when the literal reading produces an intelligible result. The court cannot aid the legislature's defective phrasing of an act, or aid or mend, and by construction make up deficiencies which are there. See Dadi Jagannatham versus Jamulu Ramulu. It is relevant to notice the observations made by the Supreme Court in Reserve Bank of India versus Peerless General Finance. Interpretation must depend on the text and context. There are bases of interpretation. One may well say the text is the texture. Context is what gives the color. Neither can be ignored. Both are important. That interpretation is best which makes the textual interpretation match the contextual. A statute is best interpreted when we know why it was enacted. Now, that's why your lordships had seen para 48. With this knowledge, the statute must be read first as a whole and then section by section, clause by clause, phrase by phrase, and word by word. If a statute is looked at in the context of its enactment with the glasses of the statute maker provided by such context, its scheme, the sections, clauses, phrases, and words may take color and appear different than when the statute is looked at without the glasses provided by the context. With these glasses, we must look at the act as a whole and discover what each section, each clause, each phrase, and each word is meant and designed to say as to fit into the scheme of the entire act. no part of the statute and no word of a statute can be construed in isolation. Statutes have to be construed so that every word has a place and everything is in its place. It is by looking at the definition as a whole in the setting of the entire act and by reference to what preceded the enactment. That's why the unamended section and the reasons for it that the court construed the expression Christchurch in Srinivas Enterprise versus Union of it. In PK Unni versus Urmala Industries, the Supreme Court narrated the principles in para 15. The court must indeed proceed on the assumption that the legislature did not make a mistake and that it intended to say what it said. Assuming there is a defect or an omission in the words used by the legislature, the court would not go to its aid to correct or make up the dictum. The court cannot add words to a statute or read words into it which are not there, especially when the literal reading produces an intelligible result. No case can be found to authorize any court to alter a word so as to produce causes omissus. We cannot aid the legislature's defective phrasing of an act. We cannot add or mend, and by construction make up for deficiency. Where the language of a statute leads to manifest contradiction of the apparent purpose of the enactment, the court can of course adopt a construction which will carry out the obvious intention of legislature. In doing so, a judge must not alter the material of which the act is woven, but he can and should iron out the creases. For Lord Denning, as he then was in C4 Court Estates versus Asher, see the observation. The Lordships had done this similar exercise in that medical admissions batch. Instead of rendering the whole section as unconstitutional, Lordships had read it down to save it from illegality. So perhaps Lordships had done what Justice Lord Denning is indicating here. Well, a judge must not alter the material of which the act is woven, but he can and should iron out the creases. In S. Gopal Reddy versus State of AP, the Supreme Court observed that it's a well-known rule of interpretation of statute that the text and context of the entire act must be looked into while interpreting the expressions used in a statute. And that courts must look at the object which the statute seeks to achieve while interpreting the provisions of the act, and that a purposive approach for interpreting the act is necessary. In State of Tamil Nadu versus Kandaswamy, the Supreme Court observed that if more than one construction is possible, this is exactly what your Lordships have done in the medical act. Supreme Court observed that if more than one construction is possible, the construction which preserves its workability and efficacy is to be preferred to the one which would render the act or provision otiose or sterile. Similarly, in Suraj ul Haq Khan and others versus Sunny Central Board of Waqf, it was observed that it is well settled that in construing the provision of a statute, court should be slow to adopt a construction which tends to make any part of the statute meaningless or ineffective. An attempt must always be made so as to reconcile relevant provisions so as to advance the remedy intended by the statute. It is also well settled that cardinal principles of interpretation of statute would come into play only when there is an ambiguity in the language used, and giving the plain commonly understood meaning to the language used in the statute is likely to lead to an absurdity. Keeping the principles of interpretation laid down by the Supreme Court, we have perused the relevant provisions of Transfer of Property Act and Article 300 Cap A of the Constitution of India. Section 5 of TP Act defines transfer of property, 54 defines sales, 300 Cap A provides that no person can be deprived of property save by authority of law. Article 300 Cap A, not being a fundamental right, does not enable a party to challenge the validity of law under Article 32 on the ground of contravention of this article. Nevertheless, the court should so interpret a statute, if possible, that the statute or section shall not affect or deprive a person of his property without authority of law. Having regard to the facts of various cases before us and the contentions and keeping in view the different provisions, Section 22 Cap A of the Registration Act, the interpretation of which is of poignant importance, has to be analyzed by dealing with its constituent elements and by harmoniously reading it as a whole and in conjunction with the other relevant provisions which will have a bearing on its interpretation. We now proceed to deal with the provisions clause-wise by referring to each clause of subsection 1 of section 22 cap A and subsection 2 to 4, keeping in view the settled norms of statutory interpretation. Clause A of subsection 1 of section 22 cap A. For the sake of convenience at the cost of repetition, said clause is reproduced hereunder. Documents relating to the transfer of immovable property, the alienation or transfer of which is prohibited under any statute of the state or central government. A plain reading of the above clause would show that any statute either of the state or central government that contains any provision restraining transfer of any immovable property covered therein is automatically prohibited from registration. In other words, when alienation of such property is prohibited by law, the registration thereof cannot be effected by the registrar, as the same would undoubtedly violate such prohibition or alienation under the state or central law. This provision therefore covers state legislation such as AP Assigned Lands Act, central law, for instance, the Urban Land Ceiling Act, where prohibition of alienation is provided under section 5. Well settled that the title would pass only on the registration of document. Hence, once a document is prohibited from registration, the registration thereof cannot be permitted so as to defeat the provisions in respective acts prohibiting prohibiting alienation. We therefore do not see any ambiguity so as to require further clarifications regarding this clause. As a matter of fact, even learned counsel for the parties did not make lengthy arguments. They did not dispute the proposition based on this clause that if alienation or transfer of any property is prohibited under any statute of the state or center, it is open for the registering authority to refuse registration of documents relating to transfer of such immovable property. For instance, prohibition under the provisions of AP Assigned Lands Act, Section 17 of AP Land Grabbing Act, AP Forest Act, reference to these enactments is illustrative and not exhaustive. Thus, it can be safely concluded that the registrar concerned would be justified in refusing to register any document dealing with a transaction of transfer of land covered by any statute. But the issue arises in a case where the parties to a document which is presented for registration state or assert that the property land is not prohibited under any statute of the state or central government. The registrar is not the competent authority to decide the question, including nature and status of land. Therefore, in our opinion, once a particular property finds place in the list of prohibited lands covered by clause A of subsection 1 of 22 cap A, registrar concerned is bound under the law to refuse registration of the document dealing with such property. In such an eventuality, Lordship may note, the only option left to the parties to the document is to approach an appropriate forum and seek appropriate relief. We would deal with the question as to who is the appropriate authority which has to forward a list of prohibited properties covered by clause A of section 22 cap A1 a little later. We however observe that when a list of prohibited lands properties under 22 cap A is sent to the registrar concerned, it shall make it clear that the forwarded list pertains to lands properties covered by clause A of subsection 1 of section 22 cap A. This is what the objects of the new enactment seeks to do, my lord, specifying that land, and also mention the statute under which the transaction is to be prohibited. So both specification of the land as well as the statute prohibiting the registration has to be mentioned, and therefore that takes care of arbitrariness or excessiveness. It would not be sufficient and proper to send one common list of lands properties covered either by all clauses of subsection 1 of section 22 cap A or even clause A without mentioning the statute which prohibits transaction. So both statute and lands have to be mentioned in the list. This is also necessary in view of the fact that land properties covered by clause A of subsection 1 cannot be equated with properties covered by other clauses, in particular clause E. Now clause B, Lordship may notice. Clause B of subsection 1 of section 22 cap A, for the sake of convenience, said clauses reproduced hereunder. Documents relating to transfer of property by way of sale, agreement of sale, gift, exchange or lease in respect of immovable property owned by the state or central government executed by persons other than statutorily empowered to do so. A plain reading of this clause would show that prohibition of registration of document transferring property by way of sale of immovable property owned by the state or central government, except when the state document is executed by persons statutorily empowered to execute on behalf of the state. Prohibition engrafted in this clause has two components. One, immovable property, which is the subject matter of state sale, is one owned by either the state or central government, and two, the deed of convenience dealing with such property shall be registered only if such deed is executed by persons statutorily empowered and not otherwise. Registrar concerned is informed about the details of any property owned by government. He is obliged to be watchful and not register any deed of conveyance like sale deed if it deals with such property and it is not executed by persons empowered to do so. Well, at this stage, it is necessary to look at the exact meaning of the word owned. Well, here the discussion is one of ownership and what constitutes ownership. I'll just skip over that, my lords, and come directly to the issue of the 81, my lords may see. Para 81 onwards, my lords may see. I'll just read that. We may also observe that merely because a property covered by clause A and B does not find a place in the list forwarded by concerned authority, and if the transaction is otherwise prohibited by a statute or it is owned by the state or central government, even if the document is registered, that would not convey the title in favor of a purchaser or transferee. This AG was endeavoring to submit, my lords, that it would merely because it does not find a, as rightly observed by the learned judge in the sixth judgment, mere act of registration would not transfer or create a title in favor of a party than what the vendor or executant possessed. Clause C of subsection 1 of 22 cap A, for the sake of convenience, my lord, said clause is reproduced here under, and this is with particular reference to Waqf or endowment lands. Documents relating to the transfer of property by way of sale, agreement of sale, gift, exchange or lease exceeding 10 years in respect of immovable property owned by religious and charitable endowments falling under the purview of AP Charitable and Hindu Religious Institutions and Endowments Act, or by Waqfs falling under the Waqf Act executed by persons other than statutorily empowered to do so. Lordship may see this. This clause deals with documents relating to transfer of property by way of sale, gift in respect of immovable property owned by religious and charitable endowments falling under the AP Charitable and Hindu Religious Institutions and Endowments Act, or by Waqf falling under the Waqf Act, executed by persons other than those statutorily empowered to do so. The clause prohibits registration of documents relating to transfer of property in respect of immovable property owned by religious charitable endowment or by Waqf unless such documents are executed by persons statutorily empowered to do so. To address the question that which properties are owned by religious charitable endowment or by Waqf, it is necessary to look into some relevant provisions of the Endowments Act and the Waqf Act. Insofar as the Endowment Act is concerned, I'll skip endowments because I'm representing the Waqf Board. If I launch direct, I'll read this also, madam. May I do that, madam?
Not necessary.
Waqf, I'll come directly to the Waqf, my lord, which is para 87. Lordship may please. Para 87 at page 279. I'm ready. Insofar as Waqf Act 95 is concerned, section 3, 5, 37 and 40 are relevant. Section 3N defines Shia Waqf, whereas section 3O defines Sunni Waqf and 3R defines Waqf. We need not go into further details of these definitions. Section 5 provides for publication of a list of awaq. Amongst other things, the state government is supposed to maintain a record of lists of Sunni awaq and Shia awaq in the state published under subsection 2 from time to time. It is advantageous to reproduce section 37, which is relevant for our purpose. The board shall maintain a register of awaq which shall contain in respect of each Waqf copies of Waqf deeds when available and the following particulars, namely the class of Waqf, the name of Mutawalli, the rule of succession to the office of Mutawalli under the Waqf deed, particulars of all Waqf properties, particulars of the scheme of administration, such other particulars. The board shall forward the details of properties entered in the register of Waqf to the concerned land record office having registration of the Waqf property. So we will do that. We will submit the entire list, my lord, and say these constitute Waqf properties to the land office. On receipt of the details as mentioned in subsection 2, the land record office shall, according to established procedure, either make necessary entries in the land record or communicate within a period of 6 months from the date of registration of Waqf property under section 36 its objections to the board. From bare perusal of this provision, it is apparent that the board shall maintain a register of Waqf containing the particulars of all Waqf properties and all title deeds and documents relating thereto. Subsection 2 of section 37 provides the board shall forward the details of properties entered in the register of Waqf to the concerned land record and office having jurisdiction of Waqf property. Concerned land office in turn under subsection 3 shall either make necessary entries in the land record or communicate within a period of 6 months from the date of registration of Waqf property under section 36 its object. Section 40 is also relevant. Decision if a property is Waqf property. The board may itself collect information regarding any property which it has reason to believe to be Waqf property, and if any question arises whether a particular property is Waqf property or not, or whether a Waqf is Sunni or Shia Waqf, after making necessary inquiry, decide the question. The decision of the board on a question under subsection 1 shall, unless revoked or modified by the tribunal, be final. When the board has any reason to believe that any property of any trust or society registered in pursuance of the Indian Trust Act or under Societies Registration Act or under any other act is a Waqf property, the board may, notwithstanding anything in such act, hold an inquiry in regard to such property, and if such inquiry, the board is satisfied that such property is Waqf property, call upon the trust or society, as the case may be, either to register such property under this act as Waqf property or to show cause why such property should not be registered, provided that in all such cases, notice of the action proposed to be taken under this subsection shall be given to the authority by whom the trust or society has been registered. Now, Manoj, para 90, a plain reading of the provisions would show that a list of Sunni and Shia Waqf will be published in the official gazette of the state with necessary particulars. State government maintains a record of lists published under subsection 2 of section 5 time to time. Apart from the properties which are gazetted, Waqf board is supposed to maintain a register of Waqf in respect of each Waqf with all necessary details and forward details of the properties entered in the register to the land record office concerned having jurisdiction of the Waqf property. On that, the land record office, according to the procedure established, is expected to make necessary entries in the land record and communicate the same within a period of 6 months. Therefore, Lordship, please see, once a property finds place in a gazette published as envisaged under section 5 or in the register of Waqf, which is the prescribed register, it is prima facie proof that the property is Waqf. So there is no ambiguity with what constitutes Waqf property, my lord. That list is given in the form of a government gazette. Once that gazette is notified, it is believed that everybody should know that it is Waqf property and therefore is prohibited for registration. So, my lord, the object of the 22 Cap A is therefore met insofar as Waqf properties are concerned. And I'm certain for Endowments Act also the same exercise is there, my lord. And if that property is included in the list of prohibited properties communicated to the registrar concerned, then any document presented for registration dealing with such property comes within the prohibition under clause C of section 5 insofar as the properties of the Waqf falling under the Waqf Act. It's also pertinent to note section 51 of the Waqf Act, which declares that alienation of Waqf property without sanction of Waqf board to be void ab initio. This is the extraction of the Act and 93, my lords, may see. Thus, insofar as clause C of subsection 1 of section 22 cap A is concerned, it is clear that immovable properties of charitable and religious endowments required to be entered in a prescribed register, the certified extract of which needs to be supplied to any applicant under section 43 of the Endowments Act. There is a finality attached to the entries of the register until the contrary is proved. Similarly, work property will either be gazetted or will be entered in the prescribed register. There is a finality attached to such entries in the register and the property is gazetted until the contrary is proved. When once the property of charitable and endowments, religious endowments are entered in the prescribed register, and when once the work properties are either gazetted or in the prescribed register, and the details of such properties find place in the list of prohibited properties made available to the registrar concerned, he would be justified in refusing to register any document presented for registration related to such endowments of charitable and religious endowments of Waqf, which find place in the list of prohibited properties, provided they are not executed by persons statutorily empowered to do so. But why this is being done, my lords, is to show the registrar by this section is not given any judicial powers or quasi-judicial powers. His powers are only limited to seeing that list of prohibited properties which are before him, which may be either endowments lands or Waqf lands or such like lands which are from A to E. He will see that and say this is prohibited for registration. There is no scope for excessive delegation of any powers, no scope for arbitrariness which the petitioners are seeking to maintain. His job, I may submit, my lord, remains the same either before the act or after the act. Now, after the act, the enactment of section 22 cap A, we are only placing, the legislature has only placed his powers in a proper statutory context by placing the objects before him and the purpose why it has to be exercised. Rather than saying you can reject any document or you can say no whichever document you want to be prohibited. Now it is clear. So his job is my lords neither statutory, neither judicial or quasi-judicial. It continues to remain administrative. It is needless to mention that the parties aggrieved have a liberty to invoke the mechanism provided under the special statutes if they intend to challenge the ownership of the charitable and religious endowments or the Waqf. The Waqf Act provides for a detailed mechanism. The tribunal is there under the Waqf Act to challenge any gazette notification. So I think that's what they're referring to. However, a question may arise as to whether the registrar would be justified in refusing to register any document presented for registration merely on the ground that the property finds place in the list of prohibited entries made available to him, though such property does not find a place in the prescribed register in case charitable and religious endowments is neither gazetted nor entered in the prescribed register of Waqf. Well, this is often happening where gazette notification is not there. A person comes to court in the form of a writ petition and says gazette notification with regard to a property is not there. However, the registrar is saying there is a list of prohibited properties before him and therefore he will refuse to register. Now, what is to be done in that case is what their lordships seek to answer, my lords, here. All such cases, however, may fall under clause E, where an appropriate claim will have to be made by such statutory authorities requesting the government to notify their claim. So merely having a list of prohibited properties insofar as endowments and Waqf properties are concerned, ballots are not enough. Those Waqf properties or endowment lands in case of Hindu endowment have to be necessarily notified in a government gazette. And to that end, our appropriate authorities will have to do so. So the court is saying, my lords, you can't refuse to register merely because it is finding a place in the list of prohibited entries. And often writs are being filed with regard to that. And the government says it is a blacklisted property or a prohibited property. That, my respectful submission, 94 para is saying that is not correct. You need to supplement it with a gazette notification. If that notification is not there, merely having a list of prohibited properties may not be enough. Well, we shall further consider this aspect while dealing with clause E, where an religious endowment or waqf claim avowed or accrued interest in any property, such a property may be brought under clause E of subsection 1 of section 22 cap A. That is, my lords, any person can call his property as waqf by making an application before the waqf authority. But that waqf authority will then have to get it gazetted. That's the job of the gazette of the waqf authority, is what their lordships are saying. In other words, if a property is either not entered in the prescribed register or gazetted, and if its ownership is in dispute, or the process of entering the property in the prescribed register is incomplete for any reason, the endowment waqf concerned perhaps may have to take steps either for its notification under subsection 2 of section 22 cap A, showing their avowed or accrued interest therein, or obtain appropriate order from the appropriate forum prohibiting the transaction in respect of such property. Therefore, my lords, my respectful submission is there no person can be heard to say that 22 cap A is arbitrary, because by virtue of that the registrar is being given power to say there is a list of prohibited properties, I refuse to register. 22 cap A is saying that's not enough, you need to have it gazetted. If it is gazetted, the endowment land or waqf, only then 22 cap A, cap A subsection C will come into the picture. So it does not suffer from the vice of arbitrariness or excessiveness, my lords, is what the full bench appears to be submitting. Now, this is my respectful submission, my lords, that both in with regard to object and reasons vis-a-vis the old act, the new section 22 cap A has addressed the problem by specifying what are those properties which are prohibited for registration. And, my lords, if the interpretation of section 22 cap A is done in the manner in which the full bench has held, my lords, there's no scope for arbitrariness at all. Any sub-registrar who says that there is a list of blacklisted properties and I won't register is acting illegally. And lordship's court is always there, my lord. Judicial review is one of the cornerstones of our constitution, is always there to protect any litigant who may be coming to this honorable court and saying that there is no gazette notification, registration refusal is bad. 22 cap A is saying you're right, go ahead and register. And, my lords, finally, the power of the registrar is not expanded by virtue of 22 cap A. The power remains the same. It is only being framed in a manner of speaking. His powers are being framed within a certain framework so that it does not give rise to excessiveness, which the old act was doing. These are my respects.
Yes.
May I please? Your lordship, kindly see the more or less on the, my learned friends are relying on the full bench judgment, my lord. The full bench judgment has not dealt with the
Yes. That you have
constitutional validity of
the provision.
Your lordship may kindly see the honorable full bench has framed the scheme. It means there was no scheme, though no mechanism is there. Your lordship kindly see the para 157. Further, as noticed earlier, the state government is empowered. May I read, man? Either so moto or on application to consider the grievances against inclusion of any property in the prohibitory list under section 22A. Registration Act is also empowered to denotify either in full or pass the notification issued under subsection 2. In our opinion, the redressal mechanism is available only with respect to notification published relating to the properties falling under class E of section 22A. Hence, any grievances of the parties with reference to the property covered by clauses A to D will have to be questioned by the aggrieved party only by appropriate proceeding before a competent court, and the adjudication by such court would be final. Further, so far as notified properties falling under class E and concerned, the redressal mechanism under section 4 of section 22A would be able to effectively address the grievances provided the mechanism thereunder is effective, expeditious, fair, and judicious. Thus, in order to make an effective redressal mechanism, we deem it appropriate to direct the respective government of both the states to constitute a committee or establish a forum within time frame, may be comprised of physical. Your Lordship may kindly see this 157 is clearly given that there is no mechanism from A to D properties are concerned, and there is a mechanism only to the properties E are concerned, my lord. That is therefore the full bench has taken so much pain to given the guidelines in 158 till the conclusion are concerned, my lord. This is only a directions by this honorable court by a full bench, my lord. Your lordship may kindly see, it is also submitted across the by my learned friend that there is a mechanism in section 2022A4 is concerned, my lord. That mechanism only related to subsection 2 only. The state government either so motu or on an application by any person or for giving effect to the final orders of the High Court of Andhra Pradesh or Supreme Court of India may proceed to denotify either in full or part the notification issued under subsection 2 regarding A to D is not there, my lord. My submission here is that, my lord, even the prohibition is made, there is no classification of properties are there. What are the documents to be considered for the prohibition is not there. My learned friend is stated that there is a gazette notification is there. Up to 1998, my lord, there is a gazette notification is the ample proof for proving that it is the work property. Thereafter, change laws are there, my lord. Several judgment is held that if inquiry is not conducted at the site, if it is under section 4, there is no document of dedication as contemplated under section 3R is there, it is not the work property. In 1979 Supreme Court taken a view that the gazetted properties is not binding on the third party. They are not binded by the gazette notification. Even the 936 registration also is concerned, my lord. Under the Waqf Act is concerned. The 36 also says that if it is after a lapse of 6 years period, it has been registered by the Waqf Board. That is also not binding on the third parties. Your lordship may kindly see. Simply, it is saying that it is the government property, it is the Waqf property, it is the so and so property. It is not, even though we can approach to the civil court or the Waqf tribunal and the endowment tribunal, but it is nothing but creating more litigation. The properties are not defined in the section what should be the government property, central government property. It is not defined there. Here my submission is that, my lord, it is submitted before your lordship is that in reply, my lord, that section 17 there is even the registration made under section 17 does not confer any title. It is a well settled law is there. I am not seeking that 22A repugnant to 17 only. My submission is that not only in isolation 17 should not be read. It should be read with 17, 49, 71, 73, 75 and 76. There is a scheme of harmonious scheme is there under the registration act, which is the central government scheme. Central act is there. That if we taken into consideration read with 17 with all these section is concerned, it is conflicting, not only conflicting repugnance with the Section 17, all other sections are there. So that, my lord, 22A totally against the scheme provided under the Central Act, my lord, it is told that it totally repugnant to the provision and it is nothing but creating hindrance and it is a blockade and blanket prohibition which is against 17 to 76 section 1 of the Registration Act, my lord. This is only my submission.
Oh,
Much obliged, my lord.
thank you.
Much obliged.
Yes, madam.
I think all are submitted. My lord, since my friend has argued this,
All right.
the conclusions arrived by the honorable full bench. My lords, they are not direction. My lord, what was summarized based on these provisions. My lord, the summary of this, my lords, where the conclusions arrived at by the full bench, they are not like a court legislating, my lord. What the court has explained all the provisions.
All right.
Yes, yes.
Arguments heard, reserved for delivery of judgment.
My lord, council is adopting reply what I made, sir. Our is the 42.
42.
42 is mine, 36, 36, the Learned Council is adopting my reply.
All right. Thank you.
Obligement.
Mark everybody's arguments heard, reserved.
Just will index, my lords, and the relevant paragraph will separately indicate. Citation.
All right, all right. For the next case. Stepler. Send it.
Let's may just have permission to make a match. Item number 1, lunch motion, may be permitted to be withdrawn because before the learned single judge, the order has been vacated.
That's why. Yes. Learned. Learned senior counsel for the petitioner, item 1. What is it?
Against a common order in the two petition,
Government business.
the appeals are filed. The appeal pertains to the non-regularization of the land, leased land in favor of the petitioners, wherein he was running an industry from much prior to 1967. I have supplied a list of dates and events. I'll quickly run through that to apprise the court of the canters of this case as it had progressed over the years. The petitioner firm was running the garment industry much prior to 1967. It was given a registered lease deed by the then AP Industrial Infrastructure Corporation for 99 years, and it continued to operate the garment industry. On 23/3/19, a notice of termination was issued by GO 225 on the ground that no activity is being carried on since 1967. The case of the petitioner appellant was that they ran the industry up to 1978, and thereafter, in view of disputes amongst the partners, there was some disturbance. In the meantime, the state issued a Panchnama dated 11/5/1990, allegedly taking possession. That was assigned in WP 7925, and on 15/5/1990, this court passed an order of status. We also made a representation to the government during pendency of the writ petition to review the issue. Then, on 20th August 1993, the government wrote to the Commissioner of Industries.
No, what is your grievance about allotment of land?
Yes, sir. Allotment of land was allotted, lease was being done. They cancelled it unilaterally. That was assigned. Then successive writ petitions were filed. At each place, the government overstepped the issue and tried to divert the land to third parties, which were also challenged. And finally, the two writ petitions which came to be heard, the learned judge recorded all these facts mentioned in the list of dates, and however did not comment upon it. The learned judge only said there is some more land left out after giving it to R3 and after giving it to the Mandal Revenue Officer to build a office. Some more lands were left out. That may be considered for regularization. This is one part of it. But the principal challenge is the very takeover of the land of the petitioner without considering his case for regularization is what is challenged in the
Regularization means you were encroacher. Encroacher.
No. I was a registered leaseholder in 1967 for 99 years. That was unilaterally terminated in 1990 on the ground I am not carrying out the activity since 67 itself. But subsequent proceedings would show that up to 78 we carried on the activity, and because of some internal dispute between the partners, it got stuck.
What is COI in your synopsis?
Commissioner of Industries.
No, we thought Constitution of India. So that
I have mentioned Commissioner of Industries, and in bracket I mentioned CO.
yes. Commissioner of India. Yes.
Page 147. Page numbers are given on the left-hand corner. On 16/11/93, the commissioner wrote asking us to withdraw the writ petition then pending to consider the case. It was withdrawn. They then asked us to pay quit rent for the period 85 to 90, and that was also paid. Subsequently, without considering our application, a part of the land was allotted to the Mandal Revenue Officer for construction. That was challenged in the writ petition. On 8/4/2002, this court passed an order of status. Then subsequently, the writ was disposed of, directing the appellant to make an application to consider the lease. That was made. The Commissioner of Industries also wrote to the government to consider fresh lease. And we submitted a fresh application also. But on 8/7/2004, the government rejects the application. Again on the same ground that no activity was carried on from 1967. And allotted the part of the plot to the third respondent. Then an appeal was made on 9/8/2004. On 8/11, the government rejected the appeal. And on 9/11, the government addressed the AP Industrial Infrastructure Corporation to allot to the third respondent 2,856 square yard at 500 rupees per square yard. The appeal was pending. Then again, a writ petition was filed, that is 214 of 2004. Then there was a instruction not to allot it, and there was an interim order passed not to dispose of sorts. Despite that, APIIC allots it to R3. Then that petition came to be allowed to reconsider the issue within 2 months.
Counsel, what happened to the partnership firm? Is it dissolved?
No, it's not dissolved. It's not dissolved.
But you said that the interstate,
Some of the partners left, but the appellant continued the business.
No, are they still in business, same business?
No, now I have been prevented from carrying on any act. Part of the land was gone away to the Mandal Revenue Officer. Part of the land was given away to.
No, what was the purpose of giving the lease? What was the purpose of giving the lease to encourage the industry? To encourage this industry.
Correct.
Now, if the very partnership firm is not in function now, where is the question of continuing the lease?
The appellant would continue. Partners may resolve themselves, and some of the partners went away. Disputes were resolved. But appellant, who was also one of the partners, will continue the business.
What is the name of the partnership firm? Only the petitioner, I think, is only the partner. Have you filed a copy? Have you filed a copy of the deed as well as the lease copy?
The partnership name was Everest Industrial Works.
Where is it mentioned in the order? Where is it mentioned in the order to whom it has been given? Who are the partners? What are the terms of the lease?
I have filed the lease deed itself, which is at page 96 of the paper book. But the lease deed was executed in favor of the appellant before your lordship, who in partnership that was continued. Earlier to that, he was carrying the name of S.B. Raman Co. But when the lease deed came to be executed in 1967, it stood in the name of the appellant. When the earlier firm was a proprietary concern, some partners came in between, but left thereafter.
Is the firm is in existence as on date?
It's a proprietary concern.
Now it has become a proprietary concern.
Yes, it's a proprietary. The lease deed itself is in the name of proprietary. The lease
Only the individual, the surviving. So the whole purpose would be defeated. What rights he has?
the lease was given to him.
No, once the partnership firm has been dissolved.
There is no partners were partners of the proprietor who who was granted a lease deed. By virtue of the lease deed, he was doing the business. In between, he took some partners to effectively carry on.
Which is why, as on date, any partners are there or
As
it's
on
on?
date, no partners.
So then we have to examine it whether the lease, whether the lease which has been now been given, can the proprietor continue it?
Proprietor can continue because it is.
Where do we get that? Where do we get that?
It's a proprietor. Bhagat Ram was given the lease deed. He can continue.
Let's see.
There is no prohibition against.
Lease, register, 96.
Lease deed is at page 96 one. That's what I am trying to point out. This indenture made on 24th March 67 by Governor of so-and-so. And Bhagat Ram Gupta carrying on business under the name and style of SB Rao. He was carrying on the business under the name and style of SB Rao. But that has not been disputed in the before the learned bench.
This is Bhagat Ram Gupta. Individual. But then his legal representative. No, who is the applicant before us? So it survives. Gave to him. It was all given to him. No.
Vote back to see the impugned order beginning from page 39. Page 39.
That's all it survives. Subsequently, partners might have communicated.
Yes.
And we see from page 39.
What if we have not utilized the premises, that's why it has been cancelled. To see the terms of the lease. That's okay. He is given in synopsis. So what, yes, so you have not utilized the land leased out to you for the purpose, you did not commence any this thing, that's why it was cancelled.
No, that statement of the respondent is erroneous by their own letter. According to the termination letter, I did not do any business from 1967. But their own letter says I continued business up to 1978 and thereafter could not continue. Therefore, the reasons assigned for cancelling it in 1990 is erroneous. Prima facie, that's the first point of error committed by the respondent in cancelling. That's why after I filed first inspection and status quo was ordered, they said you make a fresh application pointing out all these things and directed for consideration of the issue. The inspection was withdrawn and an application was already made. But again, while rejecting, they went back to their old story of not continuing business from 1967. That was what was assigned in the writ petition. Kindly see the order of rejection at page 187, dated 8/7/2004. Page 187, 8/7/2004. Sri Bhagatram Gupta noted plot number so and so on a lease for 99 years for running the ready-made dress and unit in January 1960. The lease was executed on 24/3/1967. On 12/7/67, Bhagatram requested the government for permission to start Paramount Cattle Feed and Mineral Grinding on partnership basis, as their dressmaking unit was temporarily closed down due to labor problems. Though the government accorded permission for running this industry under partnership, they could not start the. Again, in a letter dated 24/12/76, Sri Bhagatram Gupta requested government to accede the permission to sublease a portion of the plot partnership basis to Green Sharma and to run the unit the name and style of Phonax Parliament. The government wide memo dated so and so, while according permission, mentioned all leasehold rights will continue to rest with Bhagatram Gupta and his successors only, as they are lessees of the plot. But the lease failed to start the pharmaceutical industry in sublease portion, failed to revive the original dressmaking unit in the remaining piece. Then, based on the representation made by lessee on 22/10/83 through government memo dated 8/11, allowed one more year lease to take effective step to revive the dressmaking unit or start a new unit. After a lapse of 3 years thereafter, lessee failed to utilize the lease revival closed units by starting any new unit committed breach of covenant and contravened the terms of lease deed executed, was given notice through memo dated so and so to show cause why should not be taken to cancel and to re-enter the premises so and so. In response to lessee through their letter dated 26/8/87 and 85, stated in certain differences have arisen in Phonax Parliament. They could not use the premises for textile. Finally, the government-wide memo dated 12/7/89 issued show cause notice to legal representative as to why lease should not be cancelled for having committed willful breach of covenants and contravened the terms of lease deed dated 24th by deceased lessee Bhagatram Gupta. In reply to the show cause notice, lessee submitted a reply dated 13/8/89. After examining the reply, lessee and the report submitted by Commissioner of Industries, the government have issued GO 225/23/390 terminating the leasehold. Later, the portion of the plot was taken over on 11/5/8. Agreed by this order, legal as of the lessee filed inspection number so and so. While admitting the inspection, granted interim order dated 15/5/90, directing to maintain status quo pending as on the. In the meanwhile, government issued the Azamabad Industrial Termination of Regulation of Lease 1990, which was challenged by the High Court and Supreme Court. While the matter stood thus, Satish Kumar Gupta made a representation on 12/7/93 to grant a fresh lease. The representation given in 93 read with application of Satish Kumar Gupta in 2004 is examined. It is evident that Sri Ram had violated the lease, was cancelled. Subsequent representation is only a statement of intention of starting. However, past record of false actions given based on and failure to utilize that, despite the opportunities given by the government, it's now concluded that it is hard to believe the Sri Raman Code will start industry. According to the provisions of so and so, from the foregoing, since 67 onward, there has been no industrial act, and the lessee failed to utilize the land for starting a new unit or revive the closed. The lessee remained a non-user of the assigned plot since 67. there was no industrial activity. Lessee reminded non-user on the appointed date, thereby attracting provision. In view of the above, application of so-and-so to grant the freehold right has been rejected. And appeal against the order lies so-and-so. That was the same reason that from 67 he did, whereas they themselves record, they gave permission, we started a farm unit, on the, also another unit, ran for some time, that also came into the normal part of a business activity that certain difficulties come and they are not able to carry forward the activity for some time. That doesn't mean that they have given up the issue of running an industry. That aspect of the matter was not considered by the government, and thus that rejection was erroneous. That was what was challenged. Now kindly see the learned single judge's order. And it's been from P9 after narration of all these sequence at para 17. As can be seen from the letter dated 16/11/1993, so in WP 7025 of 90, which had been withdrawn.
1 minute, where are you reading?
Page 59 of Leonard Single Judge order.
As can be seen, para 17.
As can be seen from the letter dated 16/11/1993 through in WP 7025 of 90, which had been withdrawn relative to liberty or otherwise, nothing has been specified. Hence, this court may have to arrive at an inevitable conclusion that only in the light of compromise made, the writ petition has been withdrawn. The submission at length in relation to the either res judicata or applicability or otherwise of order 22 rule 3 of CPC need not be gone into elaboration. Incidentally, certain submissions were made in section 4 of the act cannot be invoked since the ingredients are not. Then the learned judge quotes a couple of judgments. Then coming at page 62 para 18. As can be seen from the material available on record, this appears to be a long drawn litigation, and the petitioner had been agitating his rights for sufficiently long time, and he had been approaching the court and knocking the doors of the court repeatedly. It may be relevant to have a glance at the order made in WP 4561 of 2003, dated 19/7/2002. And the operative portion, the court had kindly see at page 63, the last paragraph. The learned ground leader for industry submitted only a small extent of land was allotted to Mandal Revenue Officer, wherein construction is being undertaken. But however, for the purpose of allotment of fresh lease, notification has been issued by Commissioner of Industries, and the exercise is yet to be taken. He also submit as and when allotment takes place, the case of petitioner will be taken into consideration, keeping in view the earlier lease granted to his father. In view of the above, writ petition is disposed of directing petitioner to make a fresh application for grant of lease within a period of 2 weeks from the date of the and the such application, the commissioner, while considering the allotment of industrial plot on lease basis, shall consider the case of the petitioner and take appropriate decision. Then 19. The third respondent came to picture at a later point of time. As in the dismissal of the statutory appeal preferred by the petitioner under 9 of the Act in WP so and so, this court observed, as rightly contended by the learned counsel for the petitioner, the impugned order is non-speaking order, as it merely reproduces section 3(1)(b) of the Act for dismissing the appeal without considering any of the contention raised by in the grounds of appeal. For that reason alone, the order is liable to be set aside. The matter is remitted back to the appellate authority for consideration of the appeal of the fresh in accordance with law, giving notice to.
So what happened to pursuant to the direction? There was a direction, subsequent petition also was your petition, the impugned order
Yes.
disposed of with the direction to the government. Have they taken decision?
Your Lordships, kindly permit me to represent on behalf of the GP.
No. What is the decision you have taken?
Permit me to pass on the orders which was passed by the authority, Your Lordships. It was considered after giving an opportunity to the.
No, what have you done? Rejected?
Yes, Your Lordship, rejected, Your Lordships. Basing on the requirements he has not fulfilled. Under section 4 of the Ajam Industrial Area Termination and Regulation Act, Leases Act 1992, Your Lordships. It was not complied with, hence we have rejected after giving an opportunity of the. Yes, Your Lordships.
Has the public declared so? No. Yes. Yes.
This perhaps what they are referring to is the last paragraph of the.
Yes, in pursuance thereof, this
Correct.
order has been passed.
That pertains to the leftover land after allotment to the Mandal Revenue Officer and R3. That's one aspect of it. In fact, I'm not aware of it because it seems to have communicated or not. I'm not sure about.
We have informed that the order also been communicated to the parties, Your Lordship.
Because shortly thereafter, I think the appellant passed away. So I'm not aware whether the LRs did not bring it to my note. But my principal challenge is to the very rejection on the earlier part. If other part which was allotted to R3 and one that was allotted to.
So you are running the industry and kite commence production, whatever. Despite that, it has been cancelled. This is the ground, right?
That's right.
Okay. Anything else?
Because what I want to point out is two aspects to this. At every stage, they had tried to defeat it by allotting it to a third party. And in fact, the allotment to R3 was made even when my appeal was pending. There was an order of status quo, appeal was pending, and without disposing of my appeal, they unilaterally allotted it to and subsequently sent the communication of rejection, which became subject matter of the writ petition. The allotment to R3 is also at a rate of ₹500 per square yards, when the prevailing rate in that area, it's in the heart of the city, known as Mushirabad, where the cost even at that point of time was easily over 50,000 rupees per square yard. And it being a public land, they did not resort to any public auction. Straight away they made an application, they allotted.
And you were allotted by a public auction.
We were allotted by a public auction way back in 1960s. We continued. 67 was the registered listing. That's how it came up. And this is what was challenged in the writ petition. The learned judge did not deal with that. He narrated the facts but left it at that. And only gave a direction. The balance part of it has to be considered by them. That part is another aspect of the matter. But the principal cancellation and allotment to R3, depriving the appellant of its right, is unjustified, is what the appellant seeks to submit. That needs to be considered by the.
Yes.
In fact, the last page itself, page 68, the very first line, if I may point. In the light of the peculiar facts and circumstances, both in law and also on ground of equity, this court is of the considered opinion the government is not justified in totally ignoring the stand taken by the petitioner, especially in the light of assurance made at a particular point of time, in pursuance to which the petition has been withdrawn and also can be seen from subsequent events. The series of writ petition and orders made therein that equally in the light of provisions of the Act, and also specific stand taken by R3, it cannot be just and proper to disturb the allotments made by them. The court held that the petitioner was justified and the government was not justified. But yet, R3 stand was taken into consideration and refused to cancel it. And gave a direction only for the balance. That part of it is what is in question for consideration.
Yes, madam.
Page 68, my learned friend has been argued on that operative portion of the writ petition, your lordships. In the bottom of the last para, in the peculiar facts of the case, let the petitioner make a representation in detail within a period of 2 weeks from the date of receipt of a copy of this order, narrating all the facts and circumstances to the competent authority. Government and at the government take a decision in this regard within a period of 6 weeks thereafter as specified supra. The above directions, the writ petitions are disposed of, no orders as to cause. Basing on that, we have issued the notices to the parties, your lordship.
That you have rejected an order on 10th May,
Yes, your lordship. That was disposed.
16th May.
Yes, your lordship. He has participated and it was rejected, but no, that order has not been challenged so far. Hence, the writ petition prevails uphold, your lordships. My grievance is submitted to this honorable court.
Yes. When was the position taken? When was the position of the land taken?
2004 allotted to the project.
On 11/5/1990.
11/5?
To the third party we have issued.
R3 was allotted.
When was
R3 was allotted
29/11/2004 it was allotted to the third.
I'm sorry. 11/9/1990, they said we have taken possession and conducted a Panchanama. But we continued to be in operation by virtue of the order of status quo and others passed. And we lost possession on 9/11/2004 when the government unilaterally allotted to R3 a part of the portion who started construction, and thus we were dispossessed. 11/9/2000.
So he has
9/11/2000.
So he has set up, he has completed the construction, running the industry.
Yes. Yes. Yes.
All right.
That's
Yes.
only in part of the
Part of. Anything else?
I'm R3.
Yes.
I'm R3. But here I have filed a set of papers by USR I have filed the act before your lordships. By USR 69447 of 2023. I have filed the special act before your lordships. That is Ajamabad Industrial Area Termination and Regulation of Leases Act 1992. Whereas this act has undergone a change in 2000.
Give. Yes.
Whereas your lordships is page 4 of the material papers. This is page 6. Page 6. Act 15 of 92. Whereas your lordship is the person in occupation has been defined under section 2H of page 7. Person in occupation. Thereafter, this act provides for automatic termination of all existing leases by operation of law. That is section 3, subsection 1, clause A, page 8.
Yes.
Thereafter, section 4 comes at page 9. Your lordship kindly see the wording, page 9, section 4, bottom. Page 9, bottom. On termination of lease or other arrangements made under clause A of subsection 1 of section 3, a person in occupation and running an industry on the appointed date may apply for a fresh lease in the manner prescribed. So, unless, first of all, there are two conditions. His lease is not cancelled under section 3(1)A because this act has come into force on 3/6/1992. and the lease was terminated by GOMS 225, dated 23rd March 1990. So, my lord, the termination of his termination will not come under section 3(1)(a), so as to attract section 4. That is the first instance. And then, my lord, again, section, assuming without considering, suppose his lease comes under that two conditions, namely that he is a person in occupation and running an industry on the appointed date. These two conditions he has not satisfied. But because he is not a person in occupation, because according to him, I'm troubled, your lordships, with regard to the next writ appeal. I would only just show one averment in the writ appeal. I will not read everything or any such thing. Writ appeal 462, page 75. One line.
Writ appeal 460.
Writ appeal 462. Page 75. I will just read only one sentence. Para 7. I submit that
75.
75. Correct?
Yes. Yes.
I submit that the second respondent has taken possession of the industrial plot from me pursuant to the termination of lease order contained in GOMS 225 dated 23rd March 1990. This is the statement he has made. And thereafter, an order of status quo was granted in the subsequent writ petition, which was withdrawn by him. So, my lord, he has not allowed the findings of the competent authority. He has allowed the findings of the competent authority with regard to non-user, with regard to not being in possession, that those have attained finality. And nor he is questioning the provisions of section 4 in the present writ petition. But unless he questions the provisions of section 4, my lord, he can't get a right of a fresh lease.
All right. Yes, anything else? That's it. Yes, Mr.
That aspect has been considered by the learned single judge. He said pursuant to the letter of the offense to withdraw the writ petition so that they will consider. I withdrew the writ petition, the learned single judge considered it. So therefore that argument.
All right. Send the record. Don't keep it with you. With me. Yes. Arguments heard reserved for delivery of judgment. Right. This was 41, 42. 43, 44. Okay.
Regular.
Much obliged.